No mentioning before the 7 judges, sir. Send an email. You got my order. Thank you. In this matter? Oh, yeah, of course. But don't give it to us. Give it to the nodal council. He'll then put it together. No difficulty.
May please.
Do is, Mr. Paul, we'll just sort of, so that we give them enough time for the rejoinder. We'll give you about 40 minutes. 40 minutes to complete. 10 minutes for Guru and 10 minutes for Mr. Yatinder Singh. So that by 11:45 we will hand it over to them.
I'll just take 15 minutes more than the deadline given.
Now,
about an hour, I'll try to.
Mr. Paul, we know how precise you are. You can do it in 40 minutes.
Oh, no, that's a...
5 minutes.
Take the challenge. One hour for everybody together. 11:45 we are...
Can we...
Because the T20 challenge is always very stiff. Just about 10-15 minutes more.
Now 11:45. I think we have heard the matter very substantially. Now we have to hear the other side because
Mr. Nataraj and Mr. Vikramjit Banerjee also would assist for some time.
All in 1 hour. Yes.
We'll end up. We'll end up.
Generosity in these matters,
At some point of time, you know what happens is the judges also face a level of intellectual fatigue. Then you want to hear something in. You read the submissions in advance.
I hope that fatigue wasn't the result of my 20 minutes.
No, not in the least. Not in the least.
Yesterday, my lords, I was on para 8 and 9 of Basha.
Yes.
To say that the appellants cannot alter or expand the scope of reference. And taking off from where Mr. Devedi left on the principle of stare decisis. Now, whether...
That's very technical, you know. We have in a combination of 7, we are not strictly ever bound by...
I said so. I said so that I'm not saying for a minute...
Point. I think we more want an answer on the heart of the matter.
That ways. But my lord, nonetheless, I'm entitled to say that if for 57 years, Basha in no judgment discussed has ever been doubted on whether established or administered factually, should your lordships at all get into it?
That point you have made.
That is all that I'm saying, my lords.
That point is well taken. We have made the point.
Yes,
Here the other.
I'm not so much on the stare decisis, but on the issue that if that's not part of the reference order, can you completely alter and rewrite the reference question? Because the question they have rewritten.
So, Mr. Paul, I'll just tell you what my notes say. 1, scope of reference dash Basha is not under review or appeal.
Yes.
In 56 years, it has not been in question. Only question in reference was whether and is conjunctive or disjunctive.
Yes, yes.
So we formulated your point.
Yes. And my lords, also keep in mind that when para 8 and 9 was being read out to your lordships yesterday of the reference order, one consciously the word question was used there in 8 and in 9. What is it that was referred to? Yashpal. For the purposes of
That
2F were established.
Now let's get on. Now,
and my lords, one thing I missed out. In para 9, the last line and the last word was the para of Basha extracted above. So they were categorically on the question of what was extracted above, which was conjunctive or disjunctive. I'll go on to my next point.
Yes.
Next point, my lords. I must say this was a mistake on my part. I've also got it uploaded now, my lords, but I dictated to save time a short note on the 5-6 judgments relied on them by what they say, their contention and our answer. Otherwise, I could give a hard copy to your lordships because
it's already uploaded.
It is?
Yes.
Yes. Because these are the judgments they have relied on to say, because our whole submission is that there is nothing in law later on which contradicts or to which Basha is contradictory. Now, please have the first judgment, my lords, which is INRI Kerala Education Bill. My lords have that?
Yes, we can go to the second sentence.
Yes.
What I've done, my lords, is on the left-hand side are the findings and their contention based on the judgment, and on the right-hand side is our response to it. If
Yeah.
Your Lordship, my Lord the Chief Justice has that. Judgment cited and contention. In re Kerala Education Bill findings. A bench of 7 judges of this Honorable Court in re Kerala Education Bill, while examining a reference on certain aspects relating to Kerala Education Bill, opined that the provisions such as minimum salaries and qualifications for appointment of teachers sought to be imposed on minority-run schools as a condition to receive aid were regulatory in nature, and that it would not offend the right of minorities to administer under Article 30 subclause 1. The Honorable Court held that the benefit protection of Article 30 subclause 1 would be available not only to educational institutions established after the commencement of the Constitution, but also to educational institutions established prior to the commencement of the Constitution. The Honorable Court also held that
Actually, Mr. Kaul, instead of reading what Kerala holds, you can read out your second column, your response. So let's see what your response is, because Kerala.
Would Your Lordships want me to
That's
also?
better, no, brother?
Yes.
इसका response क्या है वो देख लेते हैं, more than anything else.
Very, as Your Lordships say.
I think that's better, we'll understand.
On the left-hand side, I've also given their contention based on Kerala, and now the right-hand side. Firstly, the propositions laid down by the Honorable Court in Kerala Education are not being challenged by us. The judgment in Aziz Basha also does not deny that minority institutions could have been set up prior to the coming into force of the Constitution and would still receive protection under Article 30 subclause 1. The Honorable Court in Aziz Basha firstly analyzes the antecedent history of AMU and the subsequent enactment of the AMU Act 1920 to conclude that the very establishment of AMU was not by a minority institution in the first place. Further, the administration of the university, as mandated in the 1920 Act, lies with the central government, with final decision-making retained by the Lord Rector. Such control was not merely regulatory to prevent maladministration, but substantive in nature. The above finding is also made by the Honorable Court in Aziz Basha after an analysis of various provisions of the 1920 Act. In the facts of the case, in fact, a perusal of the provisions of AMU Act demonstrate that the 5 key administrative functions, admissions, levy of fees, governing council, appointment of staff, and disciplinary powers as identified by this Honorable Court in TMFI to determine the locus of administrative control are executed primarily by the Executive Academic Council in conjunction with the visitor, earlier Lord Rector.
Can you just hold for a minute over there? Just make a note of these admissions. Levy of fees.
Statutes. Making of statutes also, if Your Lordships can add.
Under the Act.
Under the statutes and ordinances.
And ordinance.
Yes.
Therefore, the administration of university by the state cannot be simply viewed as reasonable regulations imposed in exchange for state aid. The administration of university by non-minority is substantive in nature because AMU is a central university and not a minority university receiving state aid. Then second is the judgment in Manoj Siddharaj Bhai, Sahbai versus State of Bombay, where the dual test was laid down. And here again on the right side, firstly, the present case regarding status of AMU is not a case involving mere regulations being imposed by the Center for State Aid being given to AMU. AMU stands on a different footing because the same was established by the then Imperial Legislature through an act of the then British government. Therefore, the administrative and regulatory provisions therein reflect the fact that the establishment of the university was by the central government and not by a Muslim minority. Finally, as submitted supra, the provisions of 1920 Act are not merely regulatory, but confer substantive control over the administration and management of AMU upon the non-minority bodies, including the visitor, the Executive Council, and the Academic Council. Then is State of Kerala versus Very Reverend Mother Provincial. Firstly, the Honorable Court in Mother Provincial does not state that they are rejecting the view taken by Aziz Basha. Secondly, the interpretation of the two rights to establish and to administer is consistent with how Aziz Basha interprets Article 30 subclause 1. In State of Kerala versus Very Reverential Mother Provincial, this Honorable Court merely held that non-minorities can also contribute to the establishment of a minority institution. However, Aziz Basha also does not deny such interpretation but merely holds that in the facts of AMU, the establishment of the university was by a statute and not by any minority community. Thus, the Honorable Court in Aziz Basha, after highlighting the role that is required of the minority in the process of establishment of an institution, concludes that in the facts of the AMU case, the criteria is not met. With respect to the establishment in State of Kerala versus Very Mother Provincial, this Honorable Court held the administrative powers of management of the affairs of a minority institution cannot be taken away. Even with respect to the administration, the Honorable Court in Aziz Basha undertakes a detailed analysis of the 1920 Act and after assessing the same concludes that the management of the affairs of the institution did not lie with the minority institution and was with the central government. Therefore, in Aziz Basha, this Honorable Court not only laid down the broad principles of Article 30 subclause 1, but also undertook a factual analysis of the 1920 Act to hold that the administration of AMU was never envisaged to be in the hands of minority community. No subsequent decision has held that the factual analysis undertaken by Aziz Basha requires reconsideration. Then St. Stephen's College. In the Honorable Court in St. Stephen's case discusses the ratio of Aziz Basha and then proceeds to rely upon the decision in a different case, S.K. Patro versus State of Bihar, because S.K. Patro was found to be in close parallel with the case on hand. Therefore, the Honorable Court in St. Stephen's was conscious of the Aziz Basha judgment, but did not make any finding that the finding or decision in Aziz Basha required any reconsideration. Further, with respect to the importance of historical antecedents, the importance and relevance of Mao College was already considered by this court in Aziz Basha, and only thereafter the Honorable Court made a finding that the establishment of AMU by the then legislature was the founding of a new university and the absolute dissolution of the Mao College. In fact, the Honorable Court notes the nucleus of the Aligarh Muslim University was Mao College. Thus, the Honorable Court concludes that the conversion of Mao College from a college institution into a university was, however, not by the Muslim minority. It took place by virtue of the 1920 Act, which was passed by the central legislature. At the same time, it is also important to note that in fact the Honorable Court in St. Stephen's approves the conjunctive test laid down by Aziz Basha and holds that a minority institution must be established and also be administered by a minority community. Now please have TMA Pi, the next page. It is submitted that the issue in Aziz Basha was not regarding whether admission of non-minority students would not affect the minority character of an education institution. This Honorable Court in Aziz Basha does not hold that minorities do not have a right to establish and subsequently administer religious institutions. It merely holds that in the specific case of AMU, neither establishment nor administration lay with the minority community. In fact, in TMA Pi, this Honorable Court laid down the indicia of administrative control, which was then relied upon by the Honorable High Court of Judicature at Allahabad to analyze and hold that none of the indicia of the administrative control in the case of AMU lay with the minority community. Accordingly, the Honorable Allahabad High Court thereafter found that the 1920 Act never envisaged administration of AMU by a minority. Now, my lords, coming to some of the specific points raised The next point is, my lords, the 1981 amendment does not remove the basis of Basha. My lords, the establishment of
In analyzing this aspect, we'd like you to dwell separately on the establishment aspect of Basha and the administration aspect of Basha separately.
right.
So, to what extent did the 1981, because Basha held both, that it was not established by a minority, and second, it held it was not administered by a minority.
Yes.
Now, when the 81 amendment comes, does it take away the basis of Basha both in relation to establishment and
Yes,
so
my lord.
we'll have to deal with it separately.
Yes, yes, yes.
So this is not a question, it's just a
Yes,
suggestion.
yes, I'm very grateful. My lords, the establishment of AMU by the then colonial British government is a finding based on historical fact. That the Mao College was dissolved, that a new university by the name of AMU was established, and this was a university established by the then central government and not by Muslims. These are historical facts.
So just repeat it, dissolution.
My lords, the
Of MOU.
establishment of the AMU by
The
the then
historical fact, and you identified the
when Mao
features.
College was dissolved.
Yes.
That's what I'm getting.
Then,
The Mao College was dissolved, that a new university by the name of AMU was established, and this was a university established by the government and not by Muslims. After detailed negotiation. And giving up of many rights as an institution that they may have possessed before coming forward to the central government negotiating and an act coming into place. Now, by introduction of the word,
by deletion of the word established,
by deletion
There's
of the
two
word
things.
established and amending the definition of
Of
university, you cannot remove the basis of Basha which recognized a historical fact. And that was not laid down as law by Basha but held to be a fact. Basha recognizes a historical fact. The change in legislative history is not possible in the manner the 1981 Act is seeking to do. That cannot happen. You can't change legislative history. And a historical fact cannot be revised or altered either by a legal fiction or by a parliamentary fiat. Either of the two cases. If it's a historical fact, it remains a historical fact. A legal provision can be changed. But how do you remove a historical fact? And as your lordship in Indra Sani held, that a fact cannot cease to exist only because they are denied. If a fact is there, it's there. You can't by a subsequent legislation say, I deny this fact. You can't alter legislative history. The fact is an act came into being. The fact is that Mao was dissolved. The fact is that a new university came into existence after negotiations. This is about historical facts. And that is why the late Somnath Chatterjee, my lords, one of our most erudite parliamentarians, and that is in the Solicitor General's written submissions on page 113, categorically said that changing the definition of university was, as it was done, which was established by a statute, and once an institution was established in a particular manner, such manner of establishment could not be changed through retrospective legislation, as legislation cannot change history. That is what the late Somnath Chatterjee said. You are today seeking to argue that by the change in definition of university and by removal of the word establishment, we will change a historical fact.
Reference of Mr. Somnath.
The Solicitor General's written submissions are on page 113.
You can, Mr. Call, you can continue. Ask one of your juniors to just give us, in a minute, the specific, not from the submissions, but the actual document, what page it is. Anybody can give it in 2 minutes.
Yes,
Just
yes,
don't get deflected. We'll hear it so that we can complete your submissions.
Yes, my lords, I just. As far as administration is concerned, my lords, my respectful submission is, and those are my instructions subject to correction, that the 81 Act does not deal with administration at all. It only deals with this definition of university, and for them, that's what it deals with, an establishment being removed. The minister rejects it and says we will not go into administration. Now, my lords, the second point for your lordship's kind.
I think you are on firmer ground on the second aspect as compared to the first aspect. Frankly, I have some doubts about whether you are right on the first aspect. Because when Parliament deleted the word established by the 1981 amendment, in that sense, if you are going to delete the word establishment, then the entire incorporation of the university would have to come to an end. But possibly it was open to Parliament to take a particular view that what the 1920 Act did was to give it a form of a statutory university. But it does not dilute from the fact that this was still established by
the creation of a university by a statute.
Fair enough. But on the latter part, that the 1981 does not take away the basis of Bhasha, you may be on firmer ground, because the 1981 Act makes no change to the administrative provisions of the 1922 Act at all. It leaves them intact.
I'll only endeavor to persuade your lordship.
The first point also.
And I'm equally on an equally firm ground. That's my endeavor, just to persuade the Honorable Edge. My lord, ultimately, what was
your best argument on that is, once the university is established pursuant to a particular enactment.
You can't just say it's not established.
But then,
because then you would be going back to what? There would be a void.
my lord, I can't better. That's exactly what I'm saying. That is the sum and substance of my first argument. That's what I respectfully submitted.
because something once it's established, you can't change it.
You can't then say it's not there.
But then virtually what you are arguing, and that too on the part of the respondents, where government is also doing, government is also on that side, is taking virtually now saying that this part does not vest with the Parliament.
I'm going to the extent of saying that even by a legislative,
then this part,
I'm saying so. This is my submission that by a legislative fiat or legal fiction, you can't take away a historical legislative fact. You can't alter legislative history. That's my submission. Whether the government can make it or not is another issue. I can surely make it.
There is a little problem conceptually, because it is always open to the legislature. The legislature is not bound to take notice of facts as they emerge, as you and I would think that they emerge. But the legislature is always entitled to take a artificial view of facts.
As your lordship just said,
powers the legislature. That's what they do all the time in income tax law.
as your lordship just said,
I was paraphrasing your argument, not accepting or rejecting that argument, because it's also well settled that the legislature can make laws with retrospective effect.
no difficulty.
Suppose they were of the view that they by mistaken notion use the word established there, they could have always removed it because the court acted upon that basis.
So I'll just go back to what your lordship just summarized so well. That can it be said that something was established by a legislation? Say we are not recognizing.
You are also appearing on the side of the government in the eagerness to, uphold the striking down of the 81 amendment. Let us now do something which substantially cripples the powers of Parliament. And we should be very averse to taking that kind of an interpretation.
But my lord, my submission is slightly different. I'm on the point what your lordship also just summarized.
In the effort to sustain the decision of the Allahabad High Court and get over the 81 amendment, shouldn't be doing something which, we means you, which really in that sense will substantially
but also, my lord,
dilute the powers of Parliament for the future. We have to be very careful, because what we are laying down is law for the future.
Fair enough, but what your lordship,
powers of a constitutional body.
But what your lordship also said, that at the same time, ultimately, my lord, there are actions of Parliament as well which are struck down. There are actions of Parliament which are also held to be ultra vires. The
And I'll tell you
Constitution-
why this may not be entirely correct. Parliament is entitled to say that we take a particular view of the expression established
Right.
as opposed a factual view as opposed to a legal view. Now we got your point that even on the facts, there's a historical fact with
That's
Bhakta.
all that I am saying. Manoj, that is my limited submission on that. That is
Parliament
what
can
Justice
make that
Khanna
distinction
summarized my
between-
limited submission on the point.
Parliament can make that distinction between incorporation and setting up.
Yes.
And to say that, well, what was meant by the word established, what we mean by the word established is actually the factual setting up, not the legal form which is given to it by the incorporation of a university possible. So let's not sort of, go into a wider context and sort of dilute the powers of Parliament by laying such a broad proposition that is not open to Parliament while legislating to take a view of historical facts to the contrary, even if it is embodied in a judgment of the
This
court.
meaning of,
Let's not.
all I'm saying is, my lord, this meaning of established also in a way.
That's why I
gets
said your second point, you're probably on a surer footing.
Manoj,
That you've never changed the administrative basis of the
And let me
1920 Act in
complete this,
1980.
and let me just complete it.
But now you've made your
And
point.
on established also, read it in conjunction with entry 63 list 1,
National-
where it's brought in as a university of national
That
importance.
point has already been made.
That's why I said, my lords, don't read established alone. Read it in conjunction with what did Parliament intend? Or what did the Constituent Assembly, when the Constitution was being drafted, intend? When entry 63 list 1 came in, a university like Banaras Hindu University of national importance, without any communal tag at all.
Entry 63 uses the expression established in relation to universities which are established under Article 371E. I just wanted to check whether they use the word established in relation to AMU and BHU. Doesn't matter, but that factual.
No, my lords, just for the completeness of the narrative.
Which says
Yes.
the university is referred to as AMU and BHU at the commencement of this constitution.
Right. May I, my lords, proceed with the.
There is one aspect, of course, which still is a point which may weigh in your favor, which is that entry 63 of list 1 contains a constitutional understanding in regard to the status of AMU and BHU. So it freezes that constitutional understanding as at the date of the commencement of the Constitution. Now, if the Constitution adopts a particular understanding of these two universities, these two institutions, which says institutions known at the commencement of the Constitution as AMU and BHU, can a subsequent legislature alter that constitutional understanding, which is the foundation of entry 63?
So what fell from my lord the Chief Justice,
That too without.
except for a constitutional amendment.
Of the constitutional.
Without
Yes,
constitutional.
without a constitutional amendment, you cannot.
Because now one thing is very clear, that entry 63 tells us that as an institution of national importance, these two institutions are those which were known as such at the commencement of the Constitution. And then can you, by a legislative fiat, alter that constitutional understanding which forms the basis of entry 63?
In fact,
That's the specific
Entry
point. that I
63
raised, that
entry
that
63 is a constitutional declaration.
would amount to amending the constitution. As it-
That will be true even for 1951
No, there is no change in Malod.
and 65. No, there is no
There is
change.
none, there is none.
the character of the
It's bringing
university
in-
is not.
No, but those are amendments
It's
to
bringing
the,
conformity with part.
they are also amendments.
In
with-
fact,
Three.
in fact, frankly, they bring it in conformity.
With part.
Yes. Now, my lords, the second point, since time is I've
Yes.
been, yes. My lords, the next point for your lordship's kind consideration is that the administrative functions of the AMU are primarily carried out by 4 bodies. the visitor, the executive council, the academic council, and the AMU court.
Visitor, academic council,
EC.
A visitor, executive council, academic council, and the AMU court. Now, if the 5 key administrative functions as per TMA-5, which disclose where does the locus of administrative control lie, are looked at, which are admissions, levy of fees,
Actually 6 now.
yes, governing councils, appointment of staff, disciplinary powers, and ordinances and
Now
statutes.
statutes and all.
Statutes
That
and
we have
ordinances
read.
are looked at. The locus of administrative control as executed primarily lies with the executive and the academic council in conjunction with the visitor. And the AMU court is not the supreme body. Now, what is the argument sought to be made? That 32 Muslims are always meant to be there approximately out of 180 members of the AMU court. Now, admittedly, they are not in a majority, as the legislation does not require them to be a majority. What you are seeking to say is that de facto, by fortuitous circumstances, because they happen to be in a majority, treat this as a minority character. It can't be. The legislature, if it wanted, could have done so. But the legislature consciously does not provide for it and puts it only at 32 out of 180 or approximately that number. Now, in fact, because they turn out to be more, can't alter a legislative fact that they're not meant to be in a majority, are not expected to be a majority. The legislature doesn't mandate that to happen. And the highest that can be said, my lords, is that the AMU court is one amongst many administrative bodies with essential powers vested in the executive council, academic council, which are not minority-led.
Okay, next.
Yes. Manoj, next, an argument was sought to be made that there is a difference between established by and established through. And it was said that it may have been established through a statute, but it was established by a minority. Now, Manoj, with great respect, these semantic distinctions are not borne out from the 1920 Act at all, which uses the term an act to establish and does not anywhere aver to the fact that the government is merely recognizing an existing institution to be a university. There is a huge difference, my lord, when a college like St. Stephen's College is looked at. A minority institution whose character as a minority institution is analyzed is affiliated to a secular university. That's very different. There the questions come in is, what are the nature of regulations can you put? Can you, as a condition for affiliation, say that they cannot have a separate interview? Their cutoff date can be the same or not? Can, while granting them aid, can you put regulations which are so onerous that it takes away the minority character of the institution? That's a very different category of cases. They did not come to the central government and say, create a statute, and negotiated, and a statute was passed to create St. Stephen's as a college or a university. We are dealing with a case where, for historical reasons, you came, negotiated, and ultimately, in the facts as they existed in 1920, by virtue of a statute, an act to establish, as it said, the university came into being. So you can't give those examples, and then you use semantics like by, through. It's irrelevant, because the statute doesn't provide for that.
Mr. Kaul,
Yes.
isn't St. Stephen's also governed by substantial extent by the statute and ordinances of the University of Delhi?
Manoj, maybe, but that is still an affiliated to the Delhi University. Now, if
correct.
an issue arises there because it's a minority college, they went into issues, Manoj will recollect in the judgment. Where is the chapel? The principal comes from the North India Church. Many such examples were given to establish it as a minority institution there. And still affiliation was being looked at. We are talking about the very creation. Here, the preamble in section 4 said Mao College stands dissolved. All institutions connected with it, bodies connected with it stand dissolved. Ceases to exist. Where is the parity between the two? How can you even rely on an example of St. Stephen's College to cite AMU? And AMU is then posted in list NT 63 list 1.
When St. Stephen's College decided to become an affiliate of the Delhi University, did it not give up some of its rights?
None of it.
Manoj, that is why
That St. Stephen's could have also continued the way it is, given degrees which had no value or may not have legal as or permitting to get government jobs, etc.
that is why, my lords, why I was wanting to read those judgments where your lordships told me to read the right and the left. All those judgments were cases of regulatory provisions like quality of teachers, academic qualifications of teachers, the way admissions are made, etc. Those are regulatory in nature so that academic standards are maintained.
So you are then drawing distinction. Now here you are now drawing distinction between regulation and
In
will
my
that-
note read out,
will-
yes,
will
with
that-
substantive
just-
manner
just one minute.
of control.
Just one. Will that equally apply as far as when we refer to AMU is also concerned? Did they agree to get regulated in a way when they got sought and got the government permission?
Manoj, that is
Or
our
did they give up their minority?
That
rights?
is our whole cases, and as is both recognized in the impugned order of the Allahabad High Court judgment and in Aziz Basha, that when you came and negotiated, you agreed to get the degrees recognized, all our bodies, all our Mao College cease to exist, they stand dissolved. And we will now be guided by the detailed provisions of the Act on Administration
Understood. That-
and Establishment.
That we have understood.
And governmental control is accepted. Colleges as Mao was affiliated to Allahabad, St. Stephen's was affiliated to Delhi University in this matter, Mao in its original avatar. Now, St. Stephen's continued in the same skin even after affiliation. नहीं मैं बता Manoj, that is why I said the temperatures the chapel over here and there. But St. Stephen's, as I respectfully submitted, continued in its same skin even after affiliation to a university like the Delhi University. And what were the grounds taken there? The grounds taken there were, where was the management? Management was at the minority. Illustratively, it was shown that the college looked after religious and moral instructions to students. The principal of the college was to be a member of the Church of North India or of a church that is in communion with the Church of India. All those factors came in. So it was held to be a minority institution.
And why 1920 Act contain a schedule which refers to those founding members?
Yes.
Why does the imperial legislature recognize what it calls the founding members?
Again, I would respectfully say that if a historical fact is incorporated to say these are the founding members, does that take away and does that have to be read so exclusively and selectively without reading the entire act together? If the entire act is read together merely because founding members are mentioned therein, what about the way it's established? What about the way it's administered? Will everything be overlooked? So we can't pick and choose bits and pieces to come to a conclusion that it is a minority institution. We can't pick up and say, look, here they said founders. There was another reference to the historical antecedent, but what about the core, the heart of the matter? The flesh and blood of the matter is...
Mr. Kaul, what else now remains?
Well, just one or two submissions.
All right, well, let's just formulate them so that we'll move on.
Well, my respectful submission for your Lordship's kind consideration at the end is this, that the entire argument has been that historical facts have been ignored and antecedents have been ignored. They have not been ignored. And then the argument is sought to be made that if that logic is accepted, then no minority can ever be set up as a university. Now, firstly, there is the NCMEI Act in itself, one which has its own provisions. B, there is no doubt now, historically as recognized in repeated Supreme Court judgment, that a university can only be set up under the UGC Act. But the deeming provision provides for any institution to come and seek a deeming status. So this whole argument that minorities and their rights are in danger is a completely misplaced argument of prejudice and nothing else. And lastly, my lords, the appellant said, as a continuation of this argument, lastly said that after all, what are we asking? We are just asking for a bit of reservation and you're snatching it away. That was an emotive appeal made. Now, my lords, my respectful submission is that when did you have reservation? The judgment in Basha has been in place for 57 years. You never had reservation till the 2004-5 with that then change of government, when the provision was made for reservation and which was ultimately struck down in the Allahabad High Court judgment. So which reservation is being taken away? Which right of minorities is being taken away? What is being done that the fabric of a secular country is being in any way pierced or destroyed? What is being done? You're almost making it look as if something is now being done, which completely destroys the minority character and snatches away all the rights of a minority institution. It does not do so. You're as protected as you are entitled to be under the Constitution of India as equal citizens, and whatever are the rights of the minorities under the Constitution. Otherwise, I'm very, very grateful. Your lordships have been extremely
Thank you, Mr. Kaul. Thank you.
I'm very grateful.
Yes, Guru.
That's that. My apologies if
Your lordships leave my notes.
Yes, certainly, Mr. Kaul.
if I sprint through some of my submissions, my lord, my apologies given the time frame, my lords. Broadly, 4 things that I wanted to highlight to my lords.
What is the first?
First, the importance of entry 63 and inclusion of AMU in the constitution itself in entry 63. That's one, my lords. That, in my respectful submission, is really a crystallization and cementing of the position of AMU as a non-minority national institution. That's the first point I want to highlight, my lords. Second point, my lord, the claim of AMU to minority status on the footing that a pre-constitution institution also is entitled to Article 30 protection.
What is the second point? Claim
Second
of-
point is the claim of AMU to protection of 30 on the footing that notwithstanding that it's a pre-constitution institution, it can still avail of Article 30 protection, has to be seen from two time zones or time frames in my respectful submission. Pre-constitution and at the commencement and thereafter. That's the second point, my lord. What were you prior to the constitution? What was your position? And what did you become? Or what is it that continued at the time when the constitution was adopted? That's the second point, my lords. Third, connected to that, my lords, is with regard to the fallacies which are the infirmities in Aziz Pasha has argued. There, my respectful submission is, my lords, the formulation of the contours of 30 at the instance of the appellant, my lords, is unsustainable. Their formulation of what constitutes 30 right is incorrect. I'll specifically refer to Dr. Dhawan's submission on this point, my lord. Fourth point, my lords, is 2 and 3 are really, to that extent, my lords, they overlap. Fourth point is, my lords, on the effect of the 1981 amendment. I think if there is any need to look at any case law, my lords, straight away there'll be two which directly in my submission answer the point. One is Indira Sani 2. The second, my lords, is Mulle Periyar, Constitution Bench decision of this Honorable Court. Both judgments, my lords, talk of how legislatively declared facts cannot override factual decisions of a court. Validating power, notwithstanding its plenary nature, to the extent of even being retrospective, cannot undo factual conclusions which are final and binding on parties. Direct are, my lords, Indira Sani 2 and Mulle Periyar. I've given those in my submissions, my lords. I'll show that. Now, coming to the first point, my lords will see that entry 63 is part of the string of entries in list 1, being 62, 63, and 64. 62 deals with historically important institutions, Imperial War Museum, another museum, National Museum, etc., etc. That is 62. 63, with which we are immediately concerned, my lords, deals with two named institutions, namely BHU and AMU. Thereafter, Delhi University, established under 371E, and any other institution declared by law to be an institution of national importance. 60. Take it out.
Three entries use the expression institutions declared by Parliament by law to be
Yeah.
of national importance.
Yes.
63, 64, and 62, 63, and 64.
That's right.
In 62,
Yes.
it refers to three specific institutions: National Library, Indian Museum, Imperial War Museum, Victoria Memorial, and Indian War Memorial.
That's right, my lord.
And these five.
Yes.
And then it says any other like institution
Yes.
financed by government,
Yes.
wholly or in part, and
Yes.
declared by Parliament to be an institution of national importance.
Yes.
So 62, that residuary power of the residuary clause refers to any other institution of a like
Nature. Correct.
So it has to be like, an archive.
That's right.
It's an archive or a museum.
Something
So
of
under
historical
62,
importance.
Right. On 62, the power relates to declaration of an archive
I bowed down.
or a library or a museum.
That's correct.
When you come to 63,
Yes.
it refers to two institutions,
By name.
DHU and AMU.
Correct.
And it doesn't say of a like nature. It says any other institution
I-
declared by Parliament.
I am obliged to my lord for that for one reason, my lords.
Now,
During the
64, if you
Yes.
go to 64, it refers to institutions of scientific or technical education financed and declared by law to be institutions. So 64 governs a specific class,
class of institution.
namely institutions of technical or financial education. 63 gives the general power to Parliament apart from these two.
That's right.
And 63 and 62 refers to, those archives, libraries, or museums.
Institutions of historical importance.
But all three entries use the word declared by Parliament to be
Of national importance. I bow down to my lords for the observation on 63. I'll tell my lords why.
But Guru, there's one aspect,
Yeah.
there is nothing fundamentally inconsistent
Yes.
with a minority institution being an institution of national importance.
No, there I
that
have
also
a
we
point
have
to
to, that also we have to understand.
No.
More issues. This is
Yeah.
a good.
No, I have a submission to make on that.
You can have a minority institution which also Parliament may by law.
No, I
declare to be
understand.
a national
I bow down to the point is well taken.
No,
I'm on
it's-
something slightly different. No, what fell from my lords on 63 is important. Unlike 62, which talks of a like institution, 63 doesn't have. During the Constituent Assembly debates, an amendment was suggested saying for 63 also, it has to say similar institution. That was rejected, and in the process of discussion, they talk about the national character which is non-communal of BHU and the AMU. That is what is important, my lords, for my lords' purposes. That is what I wanted to show. My lords, the Chief Justice's point is well taken that like institution is not found in 63. A similar amendment was suggested when draft 63 equivalent to 40 and 40A of the draft constitution was moved. One member, Naziruddin, he said, should it not be similar institution like BHU and AMU? Dr. Ambedkar says, no, we want width of power to take over any kind of institution because these are institutions which are of national importance, which go beyond sectarian and communal character.
Is that, just show us just that relevant part of the Constituent Assembly debate
Yes,
on when they discuss national, on this inch.
Yes.
This entry.
In my submission also, in my submission,
My written submissions, page 12. We have
Just show us
quoted,
that,
verbatim.
can we go, do you have the CAD directly instead of going through the submission? Just like-
2B, volume 2B, page 12.
no, that is in the submission.
In the submission, do you have the Constituent Assembly debate?
Debates itself we have.
Just show us that, let's go directly to the
4B,
debate.
my lords, 4B, 115.
4B.
Yes. In my submissions, we have given extracts.
No, because we'd like to read around it also.
I
around
understand,
that
Lord.
quote. Sometimes it's good to see the original text, so we understand
I understand.
page what? 4B, volume 4.
114, my lords, will start with, my lords. That relevant portion of Mr. Kamat's. And then Dr. Ambedkar also I'll show. My lords got that, my lords. 114. Can I read that, my lords? 114, Act 115. Taking my first amendment first, I feel that the acceptance of the amendment moved by Dr. Ambedkar referring to an institution which may be declared by Parliament by law to be one of national importance. I am not referring to Delhi University at all, but the second part of the amendment is fraught with dangerous consequences. I hope the House will pause to consider whether such a sweeping provision for bringing within the purview of the central government any institution, which of course Parliament may declare by law to be of national importance, is at all necessary. House will see that in the previous entry 39, which we have passed, We have given power to the Union to legislate about any institution financed by the Government of India, wholly or in part, and declared by Parliament by law to be an institution of national importance. This entry goes further and gives power to the Union to legislate in regard to institutions, whether financed wholly or in part or not at all by the Government of India. I have in mind certain institutions in this country which are doing very good work, wholly privately run, but run on efficient lines without any governmental interference. Amendment just now moved by Dr. Ambedkar shows that this grabbing instinct of the committee is growing by leaps and bounds, and if this passes muster, if this is accepted, I'm sure the day is not far distant when the acquisitive instinct of the Union will run riot, and the Union will try to step into so and so. Then the next para. As regards the two universities mentioned in this entry, the Banaras Hindu University and the Aligarh Muslim University, of course, either it may be true that they are of national importance, or because they have the communal tag attached to them, government, to show their impartial, non-communal nature, might legislate in regard to these universities. This is very important, my lords. As regards Delhi too, because the status of Delhi is not yet defined, it is perhaps desirable that it should be within the purview of the Union. But to specify here very vaguely that any other institution may also be taken over by the Union, legislated upon by the Union, though of course this saving provision is here, is there, that Parliament should declare by law those institutions to be of national importance. But in modern times, he goes into all of that. Now, this is one part where they specifically, please come back to that. As regards the two universities mentioned in this entry, the Banaras Hindu University and the Aligarh Muslim University, of course, either it may be true that they are of national importance, or because they have the communal tag attached to them, meaning to suggest, my lords, the name. The government, to show their impartial, non-communal nature, might legislate in regard to those universities. So even this person who opposed, my lords, the sweeping language of 63, where it says by Parliament can take over, says, for BHU and AMU, you are justified because you want to show that they are of national importance. They should not be carrying any communal color because of the communal tag attached to their names. And in fact, Nazaruddin, the other member, my lords, he also talks about the amendment which he wants to do. Please come to 112.
How does Dr. Ambedkar respond to all this?
Now, Dr. Ambedkar, just 1 minute, my lords. Just give me a minute on that. Can I show Nazaruddin for a minute, my lords?
Sure.
That is at 112. I have slightly altered my amendment to suit the change introduced by Dr. Ambedkar in his own amendment. I submit that Dr. Ambedkar's amendment would unduly enlarge the jurisdiction of the center, and many things which would be otherwise cognizable by the provinces would now, by virtue of the words which I seek to delete, be included within the jurisdiction of the center. The Banaras Hindu University and the Aligarh Muslim University have been regarded from the very inception as institutions of a national character and importance, and therefore they have been rightly regarded so far as national institutions, and they have been rightly placed under the jurisdiction of the Union. Then, my lords, he goes into the question of any other institution, where he says you must have it for similar institutions. That is the burden of the song in Nazaruddin Ahmad's, my lords, submission and statement in the debate. Now, please come to page 118. Now, please see, I find my honorable friends, Mr. Nazaruddin, Dr. Deshmukh, running at cross purposes. One wants to enlarge the scope of the article by adding the word academy. Other wants to limit the scope of the article by adding the word Delhi University and any other institution declared by Parliament by law to be an institution of national importance. So far as Dr. Deshmukh's amendment is concerned, it seems to me quite unnecessary to introduce the word academy because the word institution is large enough to include both university and academy. Therefore, that is quite unnecessary. With regard to the amendment of my honorable friend, Mr. Nazaruddin Ahmad, Delhi University as was pointed out by him already under the central legislature by virtue of the fact that the university is in a commissioner's province, which is subject to legislation of the center. Therefore, in introducing the words Delhi University, we are really not departing from the existing state of affairs. With regard to the subsequent part of the entry relating to any other institution declared by law by Parliament, it seems to me that it is desirable to retain those words because there might be institutions which are of such importance from a cultural or from a national point of view and whose financial position may not be as sound as the position of any other institution and may require the help and assistance of the center. In view of that, I think the last part of the entry is necessary and I am not prepared to accept this amendment. Now, with regard to the to my honorable friend, Mr. Kamath, he wanted to introduce the words research institution. He has forgotten, or probably his attention has not been drawn to my amendment dealing with entry 57A. That's with regard to another entry. Dr. Ambedkar, therefore, substantially, my lord, stands by the amendment and says the purport of 63 is that you are looking at institutions which are of such national importance, which go beyond communal character. And therefore, we will have the right vested in the parliament to declare by law any other institution of such nature. That's important, my lord. And one more aspect, my lords.
Yes.
Yes. And one more thing, my lords, perhaps that may also be useful in my lord's consideration. Please look at 112 also. Again by Dr. Ambedkar. When he's introducing the amended entry, entry 40 of list 1, the following entry may be substituted. Institutions known on the date of commencement of this constitution as the Banaras Hindu University, the Aligarh Muslim University, and the Delhi University, and any other institution declared by Parliament by law to be an institution of national importance. I submit the word university is a mistake and it ought to be institution. And I hope you shall permit me to substitute it, because they wanted it to make it a broad-based one, not just university, but an institution. There is no fundamental change in this, except that the latter part permits also Parliament to take over any institution which it thinks is of national importance. We have the IIMs, we have the IITs. In fact, IIMs, IITs, my lords would have seen, they come under 64. Now, the matter doesn't really stop there, my lords. The reason why I'm highlighting...
Is there any discussion on the importance of the use of the word national in
No,
NT 63?
there,
I didn't find it
really,
here.
there is one history to
I'm
this.
sure we'll find something in the
Drafting committee.
yeah. Why was the word national used in NT 63?
I'll tell one thing, my lords. There's a history to
There's
this.
some reason. I mean, we have to, because if
No,
you have something in the drafting committee, that will be very
No,
useful.
in fact, we discussed this, my lords. Between us, we discussed, my colleagues and all of us spread out. We couldn't really get anything specific on the expression national importance. But one thing is important, my lords. 1935 Act contains institution of national importance. What the history for that is something slightly different. The history there is education was part of provincial legislative powers. Then they wanted certain institutions to be subject to imperial legislative powers. So they added Banaras. Thereafter, they added AMU also. In fact, in my submissions, I have referred to that, my first submission. Just have a look at that. Volume 4C, just have a look at that. Volume 4. C. Yeah, that's right. I'll show that on page 43. Now, please see a glance. No, in fact, the previous one. I'm sorry, Manoj.
No, this is something else.
Page
the Aligarh Muslim University. This seems to be the bill in 1920.
1920. Now, please see the third paragraph there. Honorable members are aware that education, this is the one. Education, including university education, has in the past been a provincial subject. Legislation regarding the Banaras University was framed in consonance with that state of things, and all official control in consequence reserved to the provincial government. Recognizing the all India character of the Banaras and Aligarh universities, the rules framed under the new Government of India Act have now proposed that these two universities should be a central subject, and the responsibility in connection therewith will henceforward rest on the shoulders of the Government of India. This is the basis. At the same time, the Calcutta University Commission have commended the foundation of universities of the unitary teaching and residential type, and have proposed that universities generally should possess greater autonomy in the administration of their internal affairs. Page 43 in 4C. My Lord Justice Datta has it. I'm reading the third paragraph. That has been the case hitherto. As a necessary consequence of this constitutional development and of change of policy, various modified provisions have been introduced in this bill, which I venture to think constitute what will be recognized by honorable members as distinct improvements. In forming their own judgment regarding this claim, I would ask the honorable members to bear three fundamental and in my humble judgment, indisputable principles in mind. In the first place, no government, be it purely British, exclusively Indian, or a combination of both, can reasonably be expected to deprive itself absolutely all control over education. The real test of the liberal character of a measure like this lies in the nature of the agency and the extent of control proposed to be exercised. In the second place, in the new conditions upon which India is now entering, official control no longer means what it did in the year 1915. With the introduction of a popular Indian element in the provincial as well as the imperial government, official control will in the future have an entirely different meaning. In the third place, the substitution of control by a constitutional authority consisting of a number of persons for individual authority is on the face of it a step in the right direction. This is again indicative of the manner in which and the reason behind my lords putting in place all those provisions in the 20 Act. And this, we have encapsulated, my lords, the history of this in my submissions to A, my lords. Kindly, my lords may make a note of it. I won't read it just to save the time. My lord, this is
Could you read the next paragraph also?
then all right, I'll do that.
43 last paragraph.
A glance, may I read it, my lords? A glance at section 6.2, 17.5, 18.5 and statutes 8.1, 10.1 and 19.1 of the Banaras Hindu University Act will make it clear to the honorable members that the visitor, that is the Lieutenant Governor of the United Provinces, is the main agency of control in the case of Banaras University. In the present bill, in consonance with the central nature of the subject, much of that control is transferred to the Governor General and Council, an authority which under the Government of India Act will henceforward include 3 Indian members. Under the Banaras Hindu University Act, all new statutes or additions to statutes or amendments or repeals to statutes other than those providing for the instruction of Hindu students in Hindu religion require the previous approval of the Lieutenant Governor, who may sanction, disallow or remit for further consideration except statutes affecting the constitution of the university authorities which require the previous sanction of the Governor General and Council. In this bill, that power is proposed to be vested in the Governor General and Council. Moreover, the Governor General and Council will, when exercising the power so vested in him, have before him the opinion of the visiting board, which will include the ministers, one of whom will himself be in charge of education, so that the Government of India will be in possession of the views of this popular authority when exercising their own powers in this connection. Similar arrangements are also proposed with reference to ordinances. And though it has been considered advisable to reproduce in the present bill the provisions contained in the Banaras Act, giving certain powers of supervision to the provincial authority in order to secure that the proceedings of the university shall be in conformity with law, the agency, even for the exercise of this power, is changed from the Lieutenant Governor to the visiting body. Election of successors to the first Vice Chancellor is subject to approval by the Lieutenant Governor under the Banaras Act, while in the present bill, such election is made subject to the approval of the Governor General and Council. In the Banaras Act, the Senate consists of 50 members, of whom 5 members are nominated by the Lieutenant Governor. In the case of Aligarh University, the corresponding body to be called the Academic Council will consist of 30 members, of whom 2 only shall be nominated not by the Lieutenant Governor, but by the visiting board, constituted in the manner I've just described. Honorable members will thus see that this brief comparison between the 2 agencies of control in the case of the 2 universities constitutes sufficient indication of the liberal character of the present bill.
Is that, when they set up AMU, they had a precedent, namely of BHU.
Correct.
BHU had been set up earlier. It's indicated that, an undertaking was given to the Hindu leaders at that time, that when AMU was set up, it will be set up on the same pattern as
Pattern and lines as CF.
And therefore, AMU itself was set up on the same pattern as BHU. That I think we also find at internal page 42, middle of page 42.
Yes.
Meanwhile, the Hindu leaders, who had in their turn approached the government of India with a scheme for establishment of a Hindu university at Banaras, guided by that practical spirit, which is one of their characteristics, accepted the conditions laid by the Secretary of State, etc. An undertaking was at that time given by the government to the Hindu leaders that the university to be granted to the Muslim community
would also
be on the lines of the Hindu university.
Therefore, my lords, two things really come out. Two things really come out. One, consciously it was decided that even at the inception, it was to be taken to be an institution of national character, pre-constitution, on the lines of
But
BHP.
equally, this was an institution which was granted to the Muslim community.
That's
We can't
right.
also ignore that.
No, but one thing, my lords, as what Mr. Dwivedi was pointing out, maybe for the benefit of the community, my lords, in terms of students, etc. But please see section 8. It said that it is open to all. That's very important, my lords. Teaching of theology was for those who wanted to study it. And post-constitution also, in terms of 28.3, any teaching was subject to consent. That's very important, my lords. In fact, on that point, I wanted to just, for a minute, my lords, get out of this and get into the meaning of the expression for institutions of their choice found in Article 30. In at least 3 decisions, my lords have said what the meaning of this expression of their choice is. It's not just choice of the manner in which you do the administration as what is sought to be projected. No. Which means an institution for the development and benefit of that minority, be it linguistic or religious, for which the institution is formed by the founders. That's how you understand the expression of their choice. Give me those 2 documents. Mention that in my supplementary submissions, what the meaning of the expression is of their choice. Just note that, my lords. Volume 2, P, my lords, P for Peter. That's my supplemental submission. 2P. 2P, page 14. I have extracted from, my lords, St. Xavier's. Given that specific extract from Xavier's, my lords. The second point, my lords, arising, coming back to the point which I was submitting.
No, but if you read the second part of 96, the case of educational institution is established by a minority to conserve the distinct language, script, and culture. This was an institute which was meant to conserve the distinct language, script, and culture of the Muslims. To that extent, it's quite clear in the enactment itself.
Not exclusively for that.
No, it allowed others to come and,
Correct.
but the object and purpose was to conserve the distinct language, script, and culture of the Muslims. That's clear from the constitution.
No, there I have a caveat, my lords, to a writer to add.
From the number of places where they've used the word Muslim.
No, they do. They do. My submission in response to what is falling from my lords is this. The primary object was not that. The primary object of the institution, even according to the appellant, was to give liberal education.
To whom?
Yes, what they said to their community, but then it was an institution which was designed and made, established by, my lords, the imperial legislature to be one open to all, with liberal education. Section 8 is a clear answer to that, my lord. Section 8. That's what in my respectful submission ought to be the consideration, my lord, while looking at this. Therefore, the second point which comes out of this is this, my lords. One, institution of national character pre-constitution, even prior to the constitution, at the commencement of the constitution, while putting it bodily into the constitution, the understanding was this is an institution of national importance going beyond the communal tag. That's the second important takeaway from this point I want to say, my lords. And one more aspect. Ultimately, the proof of the pudding lies in its eating. Now, what does all this mean? What does all this translate into? By Parliament declaring by law that an institution is of national importance, what happens? Straight away, my lords, 4 or 5 features.
So what safeguarded was, it prevented the state legislatures for interfering.
Pre-constitution, correct.
It was a clear indication that the state legislatures will not interfere in these 3 issues.
It will be the imperial legislature.
It will be only the imperial legislation.
Correct.
And after the enactment of the constitution, only the central parliament.
Parliament, yes. That's right.
And the executive interfere.
That's correct.
So
That's right.
they wanted to save them or give them an umbrella, ensuring that it's only the central government and which interferes or will regulate their affairs.
For the reason, that's important, my lord. Absolutely right. For the reason that they are institutions of a national character and of national importance. That's the point, my lord. That's the reason why
That's
this
the
is.
way they distinguish them. Yes, certainly that's used. But the question which was posed by the Chief Justice also was, will branding the institution or characterizing them as an institute of national importance do away with their character as minority?
It's at two levels that I want to respond to that, my lord. It's at two levels. Number one, while as a proposition, it is right that it
cannot
need not.
read into it.
Sorry, my lord.
We can't read it as a negative stipulation.
No, I'm saying something else. First level, yes, but at level two,
It's a positive stipulation, not a negative stipulation.
no, the indication clearly being this. By declaring an institution to be an institution of national importance, the Parliament has decided that it shall acquire a character which goes beyond.
This is not a individual negative statement. It's
With
only a
respect, my lord.
positive statement.
No, I'm saying the meaning, therefore, constitutionally is that this now acquires a certain character where it goes beyond the position of all regular institutions, gets to the next level. And that's why I was saying how by being declared by law, so many other consequences follow. One of the main things, my lords, substantial government funding.
Guru, do we have the report of the standing committee which presented its report to the imperial legislation in this compilation?
Yes.
Just give us the page.
Yes. Give me the page. I'll just take it out and give it. In a minute, I'll give it. Can I just complete the submission on this, my lords? The consequence of declaring it as an institution of national importance is the substantial funding by which they become centers of excellence. Dr. Dhawan was wanting to make out that by declaration as an institution of national importance, is all that is ensured is it becomes a center of academic excellence. No, not just that. Now, in that position, it goes beyond the stage of aid to a minority institution or a non-minority institution, as the case may be. Substantial funding takes place. In fact, in my additional submission, I have pointed out from the statement of the Minister of Education on the floor of the Lok Sabha, how much money has been spent on AMU in the last 4 years. Please have a look at that for a minute. Yes. 2P, my lords. 2P, page 27, para 31.
Standing committee report by anything?
Volume
Volume?
4A, 72 minutes. 4A, 72. 4A. Just look at page 73, my lord. This select committee's report, I presume this is what my lords are looking at. Yeah, mentioned in Bhasha, my lords. Page 73 it starts. My lords want me to refer to any specific portion, my lords, in that.
We're just trying to see if there's something to highlight, which 70, volume 4A, page 70.
73, my lord.
The select committee report is of
The date,
20.
yes, 1920, my lord.
Given you enough time?
Two more points, my lords, a
Yes.
little important, my lords.
Yes.
But my lords will take it from me that I'm referring to points which are not covered by anybody else, my lords. That we are taking care to ensure that between us, my lords, there's no repetition. Just two more things. Yes, I wanted to refer to 2P, page 31 of my additional submissions, where page 27. I have given the actual expenditure of the government in the last 3 years. The last, my lords, being 1,005, volume 2P, page 27, para 31. The corresponding report, Lok Sabha report, is page 89 of the same volume, my lords. It's in a tabular form. 22-23 year, my lords, is 1,552 crores.
Right.
Just one more word, my lords, on the institution of national.
Lok Sabha report is at page 81.
The report itself is at page
81, you said, I think.
89, my lords.
89. Volume 2P.
89. And the relevant portion, my lords, is at
It's on the
90.
screen, huh? It's on the screen. Brothers, it's on
This
the
is not uploaded. Your 2P is not uploaded.
Oh, I'm so sorry.
morning page.
It was yesterday evening we had sent it.
No, I'm just.
I'm
it's
so
a question
sorry.
of fact.
Apology.
It's a question of fact. It's not.
I'm so sorry, my lords.
But
I understand the nodal council has put it up, my lords, and probably it's not been.
Yes. Semi control हो रहा है.
I understand it's there on the screen, my lords. No? Not-
आगे जाओ.
Yeah, this is the one. Just that's the page, my lords. Please see 90. My lords have it on the screen. My lords have that. The years
than
1920.
it's more than the University of Delhi.
That's true. That's
Almost
true.
double of that.
And AMU, my lords, we call has so many centers. Number of centers. One more thing on this point, institution of national importance, my lords, and then I'm done with this point. Please make a note of, I will not read just to save time. Please make a note of the discussion when the Vishwa Bharati Act was moved for declaring it by law to be an institution of national importance. There again, the national character where it goes beyond regions and particular sections is discussed. Same volume. Same volume. Please note page 43, my lords.
Which same means which volume?
The volume which I'm just referring to, 2P,
Page?
43 at 53.
Sorry.
Now the next point, my lord. Please Please, my lords, look at my original submissions and the additional submissions where I've elaborated on all these points, my lords, on the effect of declaration as an institution of national importance. Just to save time, I'm not going into each one of these points, my lords. Both the original submissions and further added in the written submission, the additional submissions, I've pointed out all of that, my lords. I've given the crux of what I wanted to submit, my lords, on this point. The second point, the effect of the 1981 amendment. If at all, my lords, there is anything to be looked at, please look at two portions of Indira Sani 2 and Mulle Periyar, my lords. Indira Sani 2, please come to my compilation of judgments, 5D.
Page
1240, para 28 and 29. There, I'll just briefly give the background, my lords. Indira Sani, 9 judges, the first one, said creamy layer shall be removed from the persons who are entitled to the benefit of reservation. Creamy layer is not entitled to the benefit of reservation. Court also directed, please form backward classes commissions, identify creamy layer, remove them. State of Kerala purports to say there is no creamy layer in state of Kerala. The validity of that action, my lords, is considered in this judgment. That's the long and short of this. Please come to paragraph 28.
1240.
5D 1240. That's the relevant part. Beginning page.
A question of validation.
Yes.
One 1218 is the beginning of the judgment. I am at 1240, my lord. May I read that, my lords, para 28? The question of validation arises in the context of section 6 of the Act. It is true that whenever legislative or executive action is declared as being violative of the provisions of part 3, it will be permissible for the executive or the legislature to remove the defect which is the cause for discrimination prospectively and which defect has been pointed out by the court. The defect can be removed retrospectively too, but by legislative action, and the previous actions can also be validated. But where there is a mere validation with retrospective effect without the defect being legislatively removed with retrospective effect, the legislative action will amount to overruling the
You
judgment.
said you have to take away the basis of a decision by
Exactly.
curing the defect which was pointed out in the original.
I bowed down. There's one important
Now, Mulla Periyar.
one more thing, my lords, one important qualification there. Where the court, let's say, my lord, strikes down a taxing statute saying the definition clause does not cover an X category. Then a validating statute can be made saying, I'm now going to cover this category also, and retrospectively, there you're removing the basis or curing the defect. A factual finding of this nature can never be part of validation. That's a very important thing, my lords. An institution, whether it has been established by a community or not, is a factual finding, which is where, my lords, para 29 is important, my lord.
But this argument also cuts
To this, in the sense, my lord?
in the sense that establishment by a statute may not be then relevant.
No, that's slightly different, my lord. The point I'm
You
making.
are right. When you argue this, that in order to see who had established the institution, you'll have to go to the promoters or the persons behind, the founders. Then you cannot argue also that the establishment is by the act of the parliament.
No, there, my lords, it's one thing for the parliament to amend in the absence of a judgment. It's something totally different. The moment there is a judgment interceding, which returns factual findings and becomes final and binding on parties, thereafter, my lords, parliament cannot step in. That's where the important qualification comes, my lords. One, a factual finding, can it be subject matter of validation? Number two, once there is a factual finding, which is a subject matter of adjudication by the judicial process, which is where, my lords, the importance of separation of powers becomes extremely relevant. Separation of powers, yes, the legislature has the power to undo acts which are held to be bad by removing the basis or curing the defect. But merely legislating to overcome cannot be done. Para 29, my lords, looks at that. Now, please come to Mulle Periyar. Same volume, 1033. 1033 at 1123. Please look at paragraph 157. Mulle Periyar again, my lords, very briefly. Judicial decision.
Page 10, volume 5D,
1123, it starts, my lords.
1123 at
1033 at 1123.
The other way, 1033, it starts.
That's right, at 1123. 5D, my lord. Same volume,
Para?
157. The question, may I read that, my lord? The question whether or not the legislature, my lord, this Suryakant has, my lords.
Yes.
The question whether or not the legislature has usurped the judicial power or enacted a law in breach of separation of powers principle would depend on facts of each case after considering the real effect of the law on a judgment or a judicial proceeding. One of the tests for determining whether a judgment is nullified is to see whether the law and the judgment are inconsistent or irreconcilable so that both cannot stand together. In what we have already discussed above, it's abundantly clear that on the one hand, there is a finding of fact determined by this court on hearing the parties on the basis of the evidence materials placed on record in the judgment of this court in Mullaperiyar Environment so-and-so, and on the other in the 2006 Amendment Act, the legislature has declared the dam being an endangered one and fixed the water level in the dam at
B on page 787, the next page, Placidum B.
Placidum B.
The
Yes.
impugned law is a classic case of nullification of a judgment simpliciter.
Yes.
As in the judgment of this court, the question of the safety of the dam was determined on the basis of materials placed before it and not on the interpretation of any existing law. And there was no occasion for the legislature to amend the law by altering the basis on which the judgment was.
I bowed on.
That's what you are.
This is precisely what I wanted to highlight.
But in this case, this legislature, the parliament amended the law.
No, on a factual aspect found by the court. That's where, my lords, the distinction.
They amended the law. Yes, you can argue as far as the finding of fact, who are the people behind or founders of the university? If there is a finding recorded in Basha, that could not have been changed by the parliament.
That's the whole point, my lords. On establishment, the clear conclusions in Bacha are threefold. I'm not on administration. Administration part has not been touched at all by the 81 Amendment, as what fell from the Chief Justice. Therefore, that's something entirely in favor of our argument. On establishment, three important things, my lords. The finding is that it is by an act of legislature. One, by looking at history. Number two, it specifically says, my lords, there was an option available to put up a university with the rider that if you did that, you were not assured of recognition of degrees by the then government. Therefore, you chose the route of having a university being established. And third, the societies which formed the basis or the beginning or the genesis, they were extinguished. In fact, one point allied to that I want to say, my lords, is part of my submissions on the third point. There are at least 2-3 legislations where the expression used is where the antecedent bodies are conglomerated with the new body which is created by the statute. Give me the page number. Page 31 of 2P, my additional submissions, I've given that example. Page 31 of volume 2P, my additional submissions. The concerned act, my lords, is the Institute of Teaching and Research in Ayurveda Act of 2020. Section 3, my lords, anteceding institutions. 2 is the declaration of the parliament that's an institution of national importance. That's at 33. Section 4, it says all those anteceding institutions, they are named. And thereafter it says are hereby conglomerated and established as a body corporate under this act. My lords got that.
Section 4.
Section, page 33. The 3 is one of the definitions. 3A, my lords, will see the anteceding institutions. Then please come to 4 in the next page. There, please see 4.1. The anteceding institutions, namely so-and-so, 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 are hereby conglomerated and established as a body corporate under this act, and on such incorporation be called the Institute of Teaching and Research in Ayurveda.
What is the effect thereof?
The effect thereof is those institutions are not extinguished or not.
Why? They still continue to exist.
No, but on the contrary, my lords, what happens is those institutions become the.
Just one. What happens on amalgamation?
Amalgamation, there is a fusion of both entities in terms of company law.
Similarly over here,
Yeah.
similarly over here, these earlier institutions get submerged and become part of the main institute.
There, the response is this, my lord.
Yes, the legislation has, in this case, used the word dissolve, but the legislation could have realized we use the word wrongly, and let's change that word.
No, there, in
Just
fact,
like established also.
no, in fact, in the case of AMU, the draft bill of 1911 used the expression amalgamation that was removed. That's the next point I wanted to highlight, my lords. Please see, compare. I've given a table of the 1911 draft and 2020 Act as ultimately, 1920 Act as ultimately made. Please come to page 5 of the same volume, 2P. Please look at that, my lords. There's a tabular column we have given. My lords got that. Just see the preamble itself, my lords, what the tone and tenor was and what it ultimately became. May I read that, my lords, for a minute?
Yes.
Where an institution, a page, my lords, of 5 of my submissions. The tabular statement is there on the screen now. Whereas an institution styled the Mohammedan Anglo-Oriental College was founded at Aligarh in the year 1875 by the Muslim community under the leadership of late so-and-so, with the special object of promoting the diffusion of Western science and literature and of training the character of the students by a scheme adopted to meet the special educational requirements of the community. And whereas from the beginning, the object of the founder and the Muslim community was to raise such a college to the status of a university. And whereas during the last 35 years of its existence, the college has very largely expanded and extended and expanded. And whereas a memorial has been presented to the government by the trustees and other representatives of the Muslim community praying for erection of a Muslim university at Aligarh and inviting attention to the advantages which a university of their own would confer on their community, to the inadequate representation within their community, etc., etc. So the entirety of that is referred to. And finally, it says, whereas it has been determined to establish a university at Aligarh. Now, please see the preamble actually enacted in the right-hand side column. Whereas it is expedient to establish and incorporate a teaching and residential Muslim university at Aligarh and to dissolve the societies registered under the Societies Act, which are respectively known as Mohammedan Anglo-Oriental College, Aligarh, and the Muslim University Association, and to transfer and invest in the university all properties and rights of their societies under the Muslim University Foundation Committee. Then please come to that part about amalgamation and conglomeration. Page 9, my lords. Section 29 in the draft.
Page 9, bhaiya.
9, my lords.
10 pe gaya.
Section 29, left-hand side column. Amalgamation of MAO College, Aligarh with the Muslim University.
Okay, amalgamation of.
My lords got that.
Yes.
On and after the date of establishment of the university, the MAO College, Aligarh, shall cease to exist as a separate corporation and shall be incorporated to the university, and all property, movable and immovable of every description, etc., etc. And all rights and powers and privileges are immediately before the establishment belonging to or were vested in the college shall, by virtue of this act, without any conveyance, assurance, or other instrument, be transferred to and become vested in the university for all estate and interest therein, respectively, of the college, and shall be applied to the objects and purposes. As distinguished from that, so the amalgamation is what is envisaged. Please see on the right-hand side column.
Amalgamate, it says incorporated into.
Yes.
Yes,
Now, section 4 talks about dissolution as passed.
right.
Very significant in my respectful submission.
Explanation is in the margin.
The marginal note.
They're off in the margin.
Two things, my lords, I'm left with now. Points 3 and 4. They are connected to each other. Proceeding on the basis, my lords, that a pre-constitution institution is also entitled to the benefit of reservation, minority protection under 30. Now, please also bear in mind, my lords, that this really stems out of a brief discussion in Kerala education, where a submission was made saying, while dealing with the Kerala Act, which was sent up to this court for advisory opinion on its validity, one of the arguments was that an institution to claim the protection of 30 should have been established after the constitution came into existence, amongst various other arguments. In that process, this honorable court says, no, there is nothing in 30 which prevents even an institution established and administered prior to the constitution from claiming the benefit of 30. That's to be borne in mind, Manoj. Now, in my respectful submission, please look at it in two time frames. What was the status of the institution pre-constitution when it was established and being administered? Second is at the commencement of the constitution and thereafter. Now, I am not going into the larger question, my lords, and without in any manner seeking to dilute what has been submitted by Mr. Rakesh Dwivedi, my lords, on whether at all they can claim to be a minority institution. Large submissions and material has been placed. While adopting that in the alternative, I am submitting this. Two things will have to be established, my lords. That you were established and administered. I am proceeding on the assumption that it's a minority. And that therefore they can claim to come within the ambit of 30. That's why I'm saying it's in the alternative. Please do not take it as diluting what has been argued on the question of minority status itself. The submission is, you ought to have been established and administered prior to the constitution. You can't say at the commencement of the constitution, I will now say here, I'm putting up my hand, I'm saying I'm a minority institution. Whatever may have been my past, I'm still entitled to the protection. That can't be.
All right, thank you.
That is one, my lords. One more thing. Post the constitution, 1951, 65, all the amendments, they really, my lords, reinforce the character that is not a minority institution. In fact, one point, my lords, the approach adopted by my lords in Ram Janam Bhoomi, where that was, of course, in the context of private property rights. My lord said, you really look at it when old claims were being made, saying prior to 1800, prior to 1700, this claim was made, that claim was made, historical wrongs, etc. My lords had two wholesome approaches. Whatever may have been recognized under the British rule and which is expressly accepted is all that can be claimed. One. So that's why I said two time frames. Look at it from the point of view of what they had before the constitution was adopted and whether it was accepted or not accepted. Alternatively, let me assume, my lords, for a minute that they had the trappings or vestiges of a minority institution in 50. I am saying, my lords, with the adoption of the constitution, the Indian Parliament had decided that it will not have even those vestiges of minority character. By the 51 and 65 amendments and thereafter, one important significant thing there, my lords, never ever was a square claim made for being a minority institution, except that skirmish, if I may put it that way, of 81 amendment. And thereafter, the 2005 proposal for giving 50% reservation. Not earlier, not after. That's a very, very important respectful point in my respectful submission, my lords. They never made a claim. Today, my lords are not looking at the validity of the 1920 Act. Will it be open to the university of all people to collaterally today argue saying, no, all this must be understood or to be held, to be contrary to what is laid down by constitution benches in respect of 30? That can't be, my lords. The first ever explicit claim is 2005 when they said 50% seats for that community. Please look at it from that viewpoint. And post-constitution also, my lords have said in Ram Janam Bhoomi, it is for the new sovereign to decide how to treat a particular right. I've given those page numbers, my lords, in my submissions. Volume 5D, my lords. (864, 865), paragraphs 989, 990.
But how that principle apply here?
The principle applies here in this manner, my lords. Prior to the adoption of the constitution, the imperial government never treated them as an institution which belongs to a particular community. One. It was on the contrary.
That's an argument from both sides, that status has to be determined first in 1920.
Correct.
And then it will have its reflection as on the date when Constitution came into
Exactly.
in Article 30.
That's right. And the second, therefore, 989, 990, my lords, and 997. My lords' decision in Ram Janam Bhoomi, where alternatively, my lords have also said, it is open to the new sovereign to either accept or not accept. Therefore, you look at it in any view of the matter. Look at it from the standpoint of what they had prior to 50. what the legislature, imperial legislature gave them or did not give them. Or assume for a minute they had some trappings at the commencement of the constitution. Entry 63, list 1, 51, 65, and the actual practice in the institution. 2005 is perhaps the first tangible claim of status.
That point you have made. Thank you.
Then, my lords, one last thing and then I'm done. I'm obliged, my lords, for a patient hearing. Their submission on 30, please have a look at Dr. Dhawan's submission. Just have a minute, my
So
lord.
what's the point that you're making?
The point I'm making is this. The submission appears to proceed on the basis that it is enough if it is shown that it's the minority community which is involved. The establishment and administration are the consequences of that status. Please have a look at that formulation, my lords. In my respectful submission, it amounts to begging the question. Please look at it, my lords. It's a little important because one of the key ingredients of their attack on Aziz Basha is on that. Please have a look at that, my lords. Page, give me the pages. 2A. 2A, my lords, page 73.
Page?
Page 73, 2A, my lords. 1A, yeah. 1A, I'm sorry. 1A. Now, please come to the conclusions. In fact, the body of the submissions also refers to that, but I thought for ease of reference, I'll come directly to this. 73, the conclusions. Aziz Basha, my lords got that, is internally contradictory in its reasoning on facts and law. 9.2. Aziz Basha failed to recognize that the word establish and administer are not preconditions to define a minority. I read their institution, it's not found there, my lords. Otherwise, it won't be complete. Preconditions to define a minority, but the consequential rights that flow from such recognition. The ingredients of the right that flow from 30 have been stated by TMA Pai at para 50 and other decisions. With respect, my lords, the position is the other way around. If you want to claim the benefits of a minority, you must show that you have established and you are...
No. There you're wrong. They're absolutely right that Article 30 says that all minorities,
Yes.
religious or linguistic,
Correct.
shall be entitled to establish and administer institutions
That's
of their
correct.
choice.
That's right.
So it postulates that you are a minority and then gives you certain rights.
No, that's right.
Namely, the right to establish and administer. Therefore, their formulation that establishment and administration are concomitant rights once you are a minority is correct. It's on the basis of plain language of article.
No, I'm saying the submission appears to be that if you show that you are a minority, then establishing an administration is really something which comes thereafter. No, on the contrary, my lords, even if you are a minority and you have been involved with an institution, you have to show that you have established it and you have been administering it.
But that's exactly the point. That you cannot claim the benefit of Article 30 in respect of an institution if you have not established it and you are not administering it.
No, this is apart from, my lords, they are...
It doesn't, whether you have established or administered an institution does not define as to whether you are a minority.
No, not in that sense. I quite see that, my lords, I quite see that.
So therefore, this is plainly a clear construction of Article 30 as it's stands.
Very well, my lords. On that point, I have made some submissions. Please have a look at my written submissions on that, my lords.
Thank you, Mr.
One last thing, my lords, and then I'm really done.
I've been
For
mentioning
all intents and
times,
purposes.
last submission of Guru.
Please see the 2006 Central Act providing reservations for SCBCs and SCs and STs. That act provides that all central institutions shall provide reservation in terms of 15 and 16. And by definition, institutions of national importance are covered by it. So AMU will have to provide that reservation, but they have not been, because there is some provision in that act which says that if the parliament declares a particular institution to be a minority institution and certain other conditions, then yes, it need not provide the reservation provided under 15 and 16. Now, AMU has not been declared as such, but still, my lords, it's not being provided. Therefore, we are looking at what, my lords, as what Mr. Sybil said, is it merely that 50% which they claim for a particular community, or are we not looking at the larger umbrella of 15 and 16 across the spectrum? For an institution declared to be of national importance with thousands of crores being pumped in, to keep it and make it an institution of excellence. And throughout has not made any specific overt claims of minority status except that 2005 or the in between 1981 Malot's amendment, which in my respectful submission is subject to the vagaries of political changes.
All right. Thank you, Guru.
I'm deeply obliged, my lords. I overshot the time, but my apologies, my lords. I'm deeply obliged for a patient here.
Navre, what is the point you want to make?
Lord, I will not repeat anything that I promise. Lord, my written submissions are in volume 2A. Page 58, Lord, it starts, but actual submissions start at page 67.
Volume?
2A, page 67.
Page 58, but starts at 60. Actual submissions start at 67. Lord, the first submission that I'm making is with respect to the scope of reference, and I will, for that submissions are made, I will not, my lord, repeat that. Lord, on facts and the law of 1920, interpretation of that act to those facts, there is a decision rendered by a 5 judges bench. And that is, my lord, something which is concluded. In reference, my lord, on principle, everything can be relooked at. But those principles will be prospectively applicable, not with respect to the decision which is made, my lord, in that judgment. My lord, there is a judgment, my lord, of your lordship's court, my lord, 3 judges. I will just, my lord, read. It is, my lord, that judgment is, my lord, brought on record before your lordships in volume 5I. It's a special only, that judgment only. My lord, the citation is 2014, volume 5, page 800. And, my lord, of that, the observations only in para 12. I will read, my lord, those 5-6 lines. Reference of a case to a larger bench necessarily has to be for a reconsideration of the principle of law on which the case has been decided and not the merits of the decision. The decision rendered by any bench is final inter partes, subject to the power of review and the curative power. Any other view would have the effect of conferring some kind of an appellate power in a larger bench of this court, which cannot be countenanced. So, my lord, this is what I am relying upon for the first proposition. My lord, the second submission that I want to make, my lord, is with respect to the, my lord, in my written submissions, I have used the term dangers. My lord, your lordship may read it as the pitfalls. Dangers in accepting the independent status of the AMU as a minority institution. My lord, 69, my lord, page 69, that, my lord, caption is there. Dangers in accepting the independent status of the AMU. Dangers in the sense, not, my lord, political sense or, my lord, social sense. Purely legal sense, my lord, that's, my lord, my submission. My lord, the first thing, my lord, for that, my lord, for appreciating this submission, your lordships will have to be, my lord, will have to bear in mind that entry 63 in list 1 will takes care of the AMU as an institution of national importance. If AMU, my lord, is conferred or recognized to be a minority institution, my lord, the parliament will be robbed of the powers, my lord, conferred under entry 63. My lord, the wide nature of power that the parliament possesses, my lord, under entry 63 will be, my lord, curtailed if, my lord, it is recognized as a minority institution.
Other than 2 institutions.
I'm sorry, my lord.
Other than 2 institutions.
Yes, ma'am. That will be undermining the authority of the parliament. My lord, conferring or recognizing a status of a minority institution will virtually taking away the powers of the parliament under entry 63, or, my lord, diluting those powers. And while interpreting 1920 Act or any act of the parliament, my lord, the court should avoid the interpretation which will result into undermining the authority of the parliament under entry 63 or any other entry. So, my lord, this is first danger that, my lord, needs to be seen in recognizing the minority status with respect to the AMU. Second, my lord, since, my lord, parliament attempted to do that by way of 1972 amendment and 1981 amendment, Lord, that also cannot be allowed to be done by the parliament because parliament virtually will be abdicating its responsibility under entry 63. Entry 63 gives a wide power, and the moment the parliament tries to, my lord, give that status to one of those institutions, my lord, as a minority institution, parliament virtually will be accepting certain restrictions on the legislative powers under entry 63. That will amount to abdicating, my lord, the responsibility which is conferred upon the parliament under entry 63. And, my lord, that's why, my lord, your lordships put a question to the learned solicitor. Can you argue this? I don't know, my lord. I need not answer that. But, my lord, Union of India cannot do something which will result into abdication of or undermining the authority of the parliament. This is second submission. My lord, if AMU is a creature by a special statute, it is, my lord, and my lord, funded almost entirely by the government. It is a state under Article 12. Lord, if it is a state under Article 12, then, my lord, it can't do something which a minority institution will be entitled to do. My lord, my learned friend Mr. Guru Krishna Kumar, my lord, pointed out in the last submission that scheduled castes, scheduled tribes, reservation, etc., will not be applicable to minority institution. That's, my lord, what the Act provides for. Virtually, my lord, though it is a state, and, my lord, bound by, my lord, mandate of Articles 15, 16, it will not be, my lord, liable to do that only because it is recognized as, it's a conflict which will arise as a result of that. So, my lord, this is my third submission with respect to the dangers of, my lord, recognizing or conferring a status of a minority institution on AMU. Lord, there is one aspect which is covered. I will just put that the caption, and that caption that, my lord, there is a fundamental difference in created under the law and created by a special law. I have, my lord, analyzed that in my reason. I will not repeat that. Lord, one word of their choice was something that was, my lord, argued on both sides. In fact, Mr. Sibal tried to give it a new dimension, saying that even if the minority institution or minority community goes to the government and requests them to create a law for it, for creation of that institution, that also will be of their choice. But my submission on this of their choice still adds a new dimension to it. Today, what way, my lord, AMU is actually functioning? Parliament has provided for everything. Court, Executive Council, Academic Council, statutes, how to be framed, what will be governed by the statute. Statutes governs, my lord, and ordinances governs even the control of examinations, even the awarding of degrees, appointment of professors, etc. It is, my lord, the choice of the parliament. It is not any community, some different entity which is taking a decision. How do I administer it? But it is the wisdom, discretion, and the decision of the parliament which controls everything. So, my lord, of their choice, in this case, it's only the choice. Therefore, I said discretion, wisdom, and the decision of the parliament, which actually, my lord, is the manner in which the institution is run. So, my lord, this is of their choice, my lord, therefore, will not be available in case of an institution like AMU, which is a creature under the statute. My lord, this aspect also is covered. I will just paraphrasing it, and I will just, my lord, not repeat that. That, my lord, the institution is, the earlier institutions, MAO, etc., are dissolved, and new institution is entities. My lord, I am putting it, the Act of 1920 achieved twin purposes. And, my lord, I am putting it, paraphrasing it, once for all. Once for all in the sense that has happened. There is something inalterable thereafter. One is dissolution of the old institutions and establishment of the new entity. That has happened once for all. And therefore, 1981 amendment cannot seek to alter something which has already occurred, and those
I think
provisions are
down now. Thank you, Mr. Navre.
Lord, there is only one thing. Last submission. Lord, your lordships have seen entry 63. BHU and AMU are both, my lord, on par in entry 63. The moment, my lord, this is again part of that pitfalls, the moment you recognize it as a minority institution, my lord, even-handedness of the parliament's power with respect to two institutions again will be affected. What parliament can do with respect to BHU will not be able to do with AMU. So, my lord, entry 63 virtually will be rewritten as a result of that. And therefore, my lord, this, my lord, the submission made on behalf of the respondents, the other side, my lord, may not be worth accepting. I am obliged to that.
Thank you.
There is last submission, but my lord, since my learned colleague reminds me, my lord, the minority status of institution under Article 30, your lordships have held that it's state specific. But if AMU is established by the parliament, treated as minority institution, what do we do with respect to its campus, my lord, on the Jammu and Kashmir? But that's the question which may arise. And therefore, my lord, that also is the conflict which may arise.
Too short.
Yes, Mr. Banerjee.
I don't want to repeat. I know I'm possibly right at the tail end, so and I'm sure.
Yes, Mr.
There are-
Banerjee, what is it?
Just two short issues, Malaz. One, I've submitted my note, which is volume 2K, Malaz. That's what I've been informed at the last moment. Just two short points. One is in relation to the three entries. Malaz, I'm not going to, I've elaborated that in my note, but I'm just placing this. That it requires to be interpreted. There are institutions of national importance in all the three entries. So Nusaitor sources has to be used to interpret all three. And Malaz, in relation to the first half, and Malaz, what has not been cited is, Malaz, I have quoted some of the extracts, Malaz, of Baba Saheb Ambedkar as well as Sardar Patel saying that minority protection, what is the intention of 29 and 30? And Malaz, I've quoted Bal Patil, which does not seem to have been cited, Malaz.
The Jain institutions claim under.
Not only that, Malaz, Jain institutions, but what Bal Patil actually does is addresses the question of minority. Malaz, only at the end, Malaz, will recall, if my lords have gone through Bal Patil, Bal Patil deals with the history of how minorities are formed. And it mentions in paragraph 33 specifically that the intention of the protection of 29 and 30 is a temporary way to ensure that the minorities finally disappear into the majority. So it's not to have a construction which will perpetuate minorities. Now, what we are doing in the present case is if we say that the state can create such minority institutions and so on and so forth, it would effectively go against the intention and objective of the interpretation of, and Bal Patil, my lords will recall, is a 3-judge bench, and my lords, I can project it, or para 33 if lordships are willing to bear with me and read the paragraph 33. My lords. It deals in great detail as to the history of, if lordship allows me to place that, my lords, I think Bal Patil would be relevant, my lords. My lords,
All right,
para 11.
We'll have a look at it.
Malaz, I only say this, para 11 and para 33.
11 and 33.
Obligements. Malaz, that's part of my note which I have enclosed.
Thank you, Mr. Banerjee.
Obliged.
Yes, Mr. Potteraju.
Lordships, my submission is on first principles. The original provisions of the Constitution had Article 12, 14, 15, 28, 29, 2, as well as entry 63 as one scheme. There's a new sovereign, the people of India, who gave them this constitution. They chose to elevate certain institutions which were established by an enactment prior to the constitution coming into force and have conferred certain rights on the citizen of this country to have access to education in institutions under 29(2). The institution in question, the Aligarh Muslim University, was a 29(2) institution in which all the seats were available to the citizen of India until 2005. So for the first time, the citizen of India have been deprived only on the basis of their religion, access to admission, consideration for admission on merits in the case of PG medical seats in 2005. The judgment in 1967 has upheld the constitutional status as a secular institution. Now, lordships are sitting in a combination of 7 judges deciding a question of seminal importance. The interpretation lodges will choose would have to be in sync with the constitutional spirit, which is upholding the doctrine of secularism, which we have actually enshrined as a basic feature of our constitution. Now, what is the interpretation which is sought to be given today? The interpretation which is sought to be given today is the original scheme of the constitution, which has conferred certain fundamental rights on an institution which is classified. My submissions in volume 2M have stated, my lords, AMU qualifies as a state under Article 12 on the day the constitution comes into force, because it is maintained by the state. I've referred to section 35 in the 1920 Act and the substituted section which came in the 1981 amendment. Both of them mandate that the accounts and audit will have to be done and be published pre-independence, post-independence in the Gazette of India. In the pre-independence, in addition to Gazette of India, in the local gazette. Further, 35(4) post 1981 mandates the audit by the Comptroller and Auditor General. The finances which are going into the institution have been demonstrated, my lords. The scheme of the constitution has created certain rights in favor of the citizen of this land. Now, those rights are now being diverted or being actually taken away by a parliamentary legislation which does not seek to even refer to the judgment of the constitution bench, much less refer to entry 63 status. With great respect, my lords, entry 63 is a status conferred on an institution, not merely a origin or a establishment of a new institution. The historical background has been set out, my lords, by Mr. Ragesh Dwivedi, Learned Senior Counsel. The background of 1916, 1920 is where we moved to a secular constitution in 1950. The new sovereign was conscious of the pitfalls of the two-nation theory and have expressly rejected it. And by rejecting it, they elevated both universities, though named as the Banaras Hindu University and the Aligarh Muslim University, as institutions of national importance. Once they elevate it, some purport has to be given to that status being conferred under the original constitution, my lords. The third point that I would like to make, my lords, is that an institution of this significance, once it is an Article 12 state, it ceases to be an Article 31 minority institution on the commencement of the constitution, because there cannot be a situation where it could have been an instrumentality of state or otherwise, but this is an institution which existed on the day when the constitution has come into force. So therefore it becomes a state on the date when the constitution comes, and it becomes Article 12. So 31 is not available to this institution, my lords. And AMU, as a creation of the statute, through its registrar, who is also a creation of the statute, cannot actually question the constitutional status of the university, which itself is a part of the original constitution. The stream cannot question the source, is my respectful submission.
Thank you, Mr.
I'm grateful.
Yes, Ms. Sachana Dave.
Wait, please, Manoj. Well, it's taking the point further. I don't want to repeat myself because already much has been said on this side. But Manoj were particularly asking about the legislative debates. And I could find one paragraph which I would just read. That's in volume 4H and page 14. I can just read it, my lord.
Just a second.
Sorry. Let's where
Volume 4H.
4H, page 14.
Just
They are talking about the national character.
Just 1 second.
Yes.
At page
14,
14.
first column, down left.
This is the 81 amendment.
Yes.
Sorry, 60. Yeah, because this is
No,
Chagla.
Malaj, 61,
Chagla was there.
additional compilation of legislative debates, page 14. Let's have that.
First column, second column.
First column, down right, left,
It starts like this.
MC Chagla.
Aligarh University is a national institution, an institution
MC
of
Chagla, right?
Yes. The last paragraph, left column, Aligarh, my lords, have it?
Yes.
Aligarh University is a national institution, an institution of national importance established by the legislature and continued by this parliament Parliament has got every right to deal with the administration of the university either through an ordinance or by changing the law. It would be a most extraordinary proposition to suggest that this Parliament, this sovereign legislature, has no right to interfere with the administration of the Aligarh University, which is Mr. Anthony's argument. It was never accepted by the British government, although there was no constitution. And even in those days, if you look at the dispatches, I have gone through the history of this when the Governor General sent the dispatch to the Secretary of State suggesting the starting of the Aligarh University. It was made incumbent that the doors of the university shall be open to persons of all castes and communities. Even that, British government would not permit a university to be set up to be financed by Indian money, which would be communal in its character. But as I said, they did not make this concession about this court, which we could not keep up because of our constitution. So, my lords, taking this further, this is with regard to the national importance, the national institution. Also, my lords, if I can say, the judgment in Aziz Basha is for a standalone institution. If I can say, this is a judgment in personam. What it is deciding is the character of the university, AMU University, as a standalone university. Both BHU and AMU are on a similar footing.
You may also want to read page 12, Archana,
Yes, my lords.
column 2.
Yes, my lords.
That is again Mr. Chagla's speech.
Yes.
Just read from the right that is conferred.
The right that is conferred upon minorities, it is important to note, is to establish and administer educational institutions of their choice. My submission to this House is that Aligarh University has neither been established nor is it being administered by the Muslim community. It is not a minority institution in the sense in which Mr. Anthony suggests. I will give him the reasons. You had first the Muslim College, which was founded by Sir Syed Ahmad. Sir Syed Ahmad asked the British government of those days to establish a university, and the British government in 1920 passed the Act of 1920. The legislature of those days passed that act and established the university. Therefore, the establishment of the institution was by legislature and not by the community. Whatever might have been the origin of the Aligarh University itself was established by the legislature. Then came the Constitution. Then in 1951, the Amending Act made certain alterations. In our own Constitution, in the Union List entry 63, it is provided that central universities and other institutions of national importance can be legislated upon the Parliament. Now, I cannot understand how it can be said that the administration is in the hands of the minorities. The administration of the university depends upon the law. During British times, it depended upon this act. After independence, it depends upon the act as had been amended by Parliament. Does Mr. Anthony suggest that it is open to the Aligarh Muslim University or the Muslim community to change the administration of the university even to the slightest degree and go contrary to what Parliament has laid down? If the minority had the right to administer the Aligarh University, then it can have any administration it liked. It can change the administration and it can close down the university. It can change the constitution of the court or the executive council. Can it do so? Even the constitution of the court, of the executive council, and of the academic council is regulated not by the minority committee, but by the Parliament. There is another aspect of the matter which Mr. Anthony has completely forgotten. He has attached great importance to the fact that under the Act of 1920, the British government, as a concession, said that the court shall consist wholly of Muslims. Now, everybody knows that the university is administered by the Executive Council and not by the court. The court, of course, is the supreme authority, and it is like a showpiece. It meets once a year. Lots of people come there and make speeches and pass resolutions. But the day-to-day administration, selection, appointments, and so on are carried on by the Executive Council. And it is significant that even in the British days, it was not provided that the Executive Council shall consist only of Muslims. That clearly shows that the British government did not concede the argument. Although there was no constitution, then the argument is now advanced by Mr. Anthony that the minority has a right to administer this particular institution. I say that this institution was not established by the minority, nor it is being administered or was ever administered by the minority community. That is the legal position as far as Article 30 is concerned.
What else, Miss, anything, what else do you want
Yes.
to?
Well, so my humble submission is, my lords, Aziz Basha, who is holding the field till today, is a good law, and it is only deciding the character of one particular university, which is AMU in this case. Well, it's the Parliament by the 1981 Amendment Act brazenly tried to overrule Basha's judgment, which it could not have done, my lords. I'm so deeply obliged
Thanks, Ms.
for
Dave. Thank you.
patient hearing.
I'm appearing for the National Commission for Scheduled Castes. Because Mr. Yogeshwar had filed the written submissions. However, my lords, there's a bereavement in his family, so I just need 2 minutes, my lords. The first submission is that the appellants have based their submissions on the extent and width of Article 31. On an interpretation of Article 31 and interpretation of TMA Pi in Inamdar, it has been held that it's only an added protective measures and it is triangular. At the top, the rights of the minority to establish institution is narrowed down and virtually zero. Hence, you cannot enter into the protection of minority institution directly as a university. Even deemed university, they first become institution of eminence. Then there is a procedure to get themselves declared. That's the first point. Second point was following this in TMA Pi and interpreting that in Inamdar, it has been held that Article 31 is now subject to Article 29(2). Once the field on any seat of any institution is occupied by 29(2), and because it is a superior right, it cannot be relegated back to an Article 31 seat. Because just 60 seconds more. Because the next point is that minority rights to establish and administer institution cannot extend to a minority university at the start. Fourth point is, Lords, the case of St. Stephen's. If we look at the factual ambit, St. Stephen's clearly said that it was established to spread the gospel, and the same charter of spreading the gospel was also registered with Delhi University. And a ritualistic religious head, that is the bishop, occupies the position as the chairman and nominates bodies. Mr.
Yatindra Singh.
Sir, volume 2C.
Give Mr. Yatindra Singh.
Your Lordships granted me 5 minutes. Probably I cannot finish in 5 minutes.
Tell us what the point is. Of course, we'll hear.
Yeah. Please inform me when the 4 minutes are over. 1 minute time, I want to tell your Lordships something which probably even they don't know about their own university. And there's a one particular case.
Why didn't we begin with that then?
My lords, I'm sorry. Lord, I have 5 submissions to make.
Yes, Mr. Yatindra.
And Lord, I will argue the traditional way. My Lord, I will feel more comfortable. Just pass on. I will not, this doesn't contain any of the annexures, only my written submissions. There are 7 submissions. Submission number 1 is, number 1 is plain language should be given natural meaning and should be read as and not or. Second submission is,
Where is that, Mr. Yatindra?
your Lordships may have my this submission, and there's a
Page? What page?
written submissions, page 2.
Page 2, all right.
My lords. Second is, university was, AMU was established by, it was not established by Muslims. The third one is that it was never being administered by minority Muslims. And the fourth one is, without changing the basis of Basha case, the legislature cannot reverse it. First and 4 are settled point. Second and third are very well dealt by Solicitor General. I have mentioned them in Annexure A. Of course, my Lord, I have given entirely a different color than what the Solicitor General has given. Your Lordship's pleasure is, if you want to read it, your Lordship may read it or omit it. Now, my Lord, I come to the 5th point. What is the meaning of the word minority? Mr. Dwivedi has elaborated a lot. I must confess, it is a very novel way he put it. And your Lordship will deal with it, the treatment that it deserves. But actually, to my mind, minority in Article 30 does not mean numerical minority, which is the general trend of this court. It means electoral minority. A minority that cannot affect any elections. Like take up the case of Zoroastrians.
But it will vary from constituency to constituency. There may be some constituencies where you can certainly affect the elections.
Milord, Your Lordship,
So do you look at it at the whole statewide level, the
Your Lordship, just permit me to just complete this point, then ask. Otherwise, I just want to finish within 5 minutes.
Yes,
I want to finish it.
yes.
We will continue after lunch.
Milord, democracy is a basic structure of the Constitution. Lord Acton, in his Essays on Freedom, says, most certain test by which we judge whether the country is really free is amount of security enjoyed by minorities. That's Lord Acton in his Essays on Freedom. It is mentioned here in paragraph number 2, Milords. This is the reason why rights to minorities were given under the Constitution. Now, if this is the case, then any minority which affects the election results is not a minority under Article 30, but like take up a case of Zoroastrians, that is Parsis and Iranis. Those who came 800 years ago, Milord, Persia was there, they are known as Parsis. Those who came 200 years ago, Iran was formed, they are known as Iranis. Now, they are about less than 1%. Bauds are less than 1%. Sikhs are less than 1%. They can't affect, Christians are 2.4. They can't affect any elections. Muslims in 211 census were 14.2%. But their population is the highest. My Muslim friends, when I talk to them, how much do you form the population? They say, now we have become 23%. So Muslims as a minority affect the elections. And that is the lot, if Bhindawale was creation of Mrs. Gandhi, then Owaisi is a creation of BJP. They want to divide the Muslim vote. Wherever they combine together, they win. You will have your chance. You will have your chance. But that's the way I thought.
We not steer away from the area of constitutional law.
But not your lordship's way. You'll reject it. Your lordship may reject it. I'm again saying that. But what I'm trying to say is.
Let's not comment on
all right.
Political personality.
Your lordship may not comment it. Your lordship may hear the next sentence which I'm going to say. Because I just mention it as a reference. Your lordship, this court is not competent to decide this question, whether they affect any elections or not. That is why, my lord, I mention that your lordships may have some kind of commission may go into this question. That's all.
So according to you, Muslims are in a position to affect electoral outcomes, and therefore they are not a minority, according to you.
That's right. And for that, your lordships cannot go into this. No court can go into this question. A commission may be formed. For that, I was laying down the basis, my lord. I also know, I understand much better than Mr. Sibbal what are the limitations of the court. As a judge also, as a lawyer also. This is all that I have to say on this point. My lord, the Chief Justice has asked a particular question to Mr. Kaul. He gave a particular answer. I have given a different shade to it. If your lordship may have page 4. Paragraph 4. I'll just read it. The 6th and the 7th one, I'll read first the submission, and then I'll read my answer. 6 is the Principal Act, that's the original act, as amended from time to time, was further amended in 1981, the 1981 amendment. By this amendment, the 4 major changes were claimed. The most important change is Section 2L. Definition of the university. Then your lordship may come to the 7.7a. Assuming though not admitting that basis of Basha case was changed, thus rendering it the Basha case as no longer a good law, then these amendments are illegal on the following ground. Number 1, They are arbitrary and illegal. B, they go against the secularism and equality basic feature of the Constitution. Point number 6 and 7 are dealt in page number 4.
Thank you. Thank you so much. Now,
No,
all
I'll just take 2 minutes more. Just let me complete.
Yes, certainly. Yeah, tell us, we will hear it for a minute.
Sure. I'd like to read this particular point.
Sure, you can read it. Which point, Mr.
Page 5. No, page 4.
Page 4.
Look, I'll take 5 minutes more in case your lordship can give me just 5 minutes more after the. All right.
Seeking 5 minutes, then we'll take on reading it. Yes.
6 and 7.
Yes.
In Basha case, it was held that AMU was established by the Principal Act. Kindly see the second submission on Annexure A. This finding cannot be reversed unless the basis is changed. This can only happen if the status quo ante or the way the things were before the Principal Act came into existence happened. In other words, the Principal Act is repealed and administration as well as properties are reverted back to MAO. Declaration in section 2L, broadly providing the university to mean educational institution of their choice established by Muslim, is not inserted with retrospective effect and is pure fiction. As in Haddock and Haddock, that's a dissenting opinion of Justice Holmes, which later on became the majority opinion. Fiction always is a poor ground for changing substantial rights. It's a dissenting opinion, but some words of wisdom. Then you'll also come to next page. There is no change in the basis for decision in the Basha case. The legislature cannot reverse it. Section 2L providing artificial definition to the word university is arbitrary. An arbitrary statute provision violates Article 14 and 16. I mentioned number of acts, but Lok Prairie case is the best case for all. Then secularism and equality are the basic feature of the Constitution. I have cited Justice P.B. Gajan Gadkar. Probably this book is not there with your Lordship library. I have the book in case your Lordship wants it, though I have annexed the relevant pages there. Then there is Austin Daniel quotation. I don't want easy. There's a very good book by Justice Chedappa Reddy, where he talks about secularism was not part of the Constitution. Sorry, was nowhere mentioned in the original Constitution, but how it was part of the Constitution, that's what he said. And the crux of all this is Indian secularism respects all religions. It does not favor any particular religion. Once you establish the institution for a particular religion, it violates the basic principles of equality, secularism, Article 15. Now, look, this is a one particular case was not mentioned precedent. Let me explain this and then I'll finish. It was yesterday my young team suggested to me to put it there. You lots of must have read Spider-Man comics in your childhood. Spider-Man has a kind of a toy. From here, he can throw this web. Now, this was subject matter of patent dispute. It went up to Supreme Court. The Supreme Court was, US Supreme Court was asked to reverse a decision which they have already taken. What they ended up saving, the advice of Uncle Ben to Peter Parker. With great power comes great responsibility. Will it be your Lordship's pleasure? And they did not overrule it. That case was 51 years old. Here it is 55 years old. Kindly read what the US Supreme Court.
But they overruled Roe versus Wade.
Your Lordship will read it here. I will read, which is in my favor. Dr. Rajiv Dhawan is a very competent lawyer. He probably I personally rate him as somebody who knows the law, there's no other person who knows as much law as Dr. Rajiv Dhawan. I have a great fascination. I grew up doing a hero worship for Rajiv Dhawan. He used to live very across the road. Hero worship for him.
I'm embarrassed.
No, Rajiv, you are undoubtedly one of the greatest advocates India has seen.
Thank you.
Your Lordship, we'll have a look at it. Huh?
We'll have a look at it. Thank you.
Can I read that particular line?
No, we've seen that judgment, yes.
And just one more. Look, one more incident I'll try to tell your Lordship. That will bear in mind. They're not 30 seconds, I'll take. Look, Andre Vail was the greatest mathematician of last century. He was impressed by Gita. And during World War, when all the scientists were running away, he was a Jew. He came back to India. Schrodinger was supposed to come to India. He got appointment at Allahabad University, and he got, unfortunately, a professorship in Aligarh Muslim University. Now, he was impressed by Gita. India was a land of promise. He wanted it to be, he always used to quote Gita, he used to take term. There's a principle of equivalence. He says, there's a new avatar. Like Vishnu had 10 avatars, that's how he used to do. And unfortunately, he was trapped in AMU. Now, AMU had an atmosphere, which was, say, let's say, put it, anti-Hinduism kind of a thing. And they tried their level best that Lakshmi, hear me. Look, there's some relevance. There's some relevance, otherwise I wouldn't have insisted. He went back. He left AMU, embarrassed. Had he been here, India would have been, AMU would have been Princeton. AMU would have been Stanford. And India would be producing one of the finest mathematicians, and we lost that. I'm obliged. Oh, yeah.
Now, anything else that has not been said, we'll give you
Yes, I have.
30 seconds. Yes.
Sir, 30 seconds I will complete. Sir, volume 2C, page number 2, and I will highlight only 2 points of my written submission. And
What is the points? Just say, tell us already.
to consider the minority status of the Aligarh Muslim University under Article 30 of the Constitution, we have to examine, can an educational institution created by the Parliamentary Institute enjoy minority status under Article 30 of
Mr. Sharma, this has been argued, repeated.
Sir, let me, I am completing the chair, sir. Sir, please 1 minute. If the answer is yes.
50 बार यही हुआ है इस बहस इसी point पे आप.
That side, so that's why. Please 1
You are supporting that side.
Sir, being an intervener, and as a respondent, any respondent can support.
You are supporting the petition. You are supporting the petition.
Yeah, sir.
I don't think they require your support right now. You argue.
Please 1 minute. Sir, I am only requesting you.
Yes.
Sir. Then there can be 2 ways. If an educational institution has been established for minorities under the Act, it should be declared a parameter for granting it minority status under Article 30 of the Constitution. If the spirit of creating education
Yes,
Supplement.
yes, I am not taking any further time in this matter. If the court permits, I'll give my written note and I'll take it.
Yes, Mr. Tapia, ladies. Thank you so much. ये अपने appearances दे दिए हैं.
Your Lordship, kindly permit me to, my Lord,
Yes, Mr. Dhawan.
I'm just taking my.
Yes, Dr. Dhawan.
Upload my additional.
Sure, no problem. You can upload that. No difficulty.
1-2 pointer is time.
But give it to the nodal council. Don't upload it yourself.
The nodal council is uploaded.
Perfect.
But
Yes, Dr. Dhawan.
if time, my Lord, remains, my Lord, I may be permitted.
We'll see at the end.
5 minutes at the last.
Yes, Doctor.
But on a point of levity, my lord. I said, on a point of levity, flattered though I am, but the only authoritative, my lord, jurists in this country are your lordships. My lord.
No.
One has to be absolutely clear about that. I want to apologize to your lordships.
This
my
was a
lord.
little bit of good neighborly behavior coming in from Allahabad.
My lord, I interned with Mr. Sibal and I told him, tell me how 500 pages can be reduced to 3. If you can teach me that, then I'm prepared. Otherwise, I'm not. So he gave me lots of briefs to read, my lord, and he is my guru. My lord. So this side, I don't go beyond that to Allahabad. My lord, I'm sorry that I've interrupted, my lord, and I apologize. There have been 2 views, my lord, given about me, my lord. One is that I come out blazing
with all guns blazing. The other I found, my lord, the other day was Dr. Rajiv Dhawan was the other senior counsel who made his own detailed submissions with a melange of legal acumen coupled with passion, thereby exacerbating the attack. I think this is good. Now, my lord, kindly, my lord, 1F, my lord, if your lordships will.
Yes. That has been opened here, it can be.
Excellent.
Okay.
Upload nahi hua.
It's on the screen. It's not a.
Okay, yes, sir, sir, yes, sir. But you should. It's okay, but what I'm trying to say, you put everything in this.
Is it uploaded, my lord?
Yes.
Lords, in my reply, there are some questions that fell from your lordships, my lord. The question of indicia, for example, fell from your lordships. The questions, my lord, of surrender versus continuity has been argued, and therefore I have to respond to that, my lord. National character versus and excellence. Therefore, my lord, I'll briefly take your lordships through all that. If your lordships will just see the index first. This, my lord, is a mixture of what they have argued that I have to respond to, and some of the points, my lord, raised by your lordships. Now, my lord, much has been said about the scope of reference. And it has been argued that your lordships are just to answer the unanswered question in TMA Pi. My submission on page, what would be the PDF? Page 2, my lord, is that the reference in this case, not having been delineated by the court, has to be abstracted, my lord, from the 81 reference, my lord, and more importantly, it has to be abstracted, my lord, from the 2019 reference. Now, my lord, on page 2, in 1.2, I say the reference is not on a single AC. And then, my lord, in 1.3, I have indicated what can be gleaned from the reference, my lord, in 2019. So the first point is, was Bhasha correctly decided? Does it suffer from internal contradictions and reasoning on facts and law? Aziz Bhasha is squarely raised, I won't read the reference again, my lord, is squarely raised as a point of reference, my lord. Aziz Bhasha needs to be reconsidered in the light of earlier and subsequent decisions, my lord, that we have argued earlier. I won't labor it. The effect of Aziz Bhasha on the future decisions of the Allahabad High Court, which applies Aziz Bhasha completely and strikes down the statutory character to the 1922 Act through the 1981 amendment. Is it a usurpation of judicial power? I don't think I need to labor too much on this, my lord, because it's in my original written submission, my lord, with the various case laws that support it. Then, my lord, what is the effect of the National Commission for Minority Educational Studies? Now, the important point there, my lord, is it recognizes the rights of minority under Section 10, which I'll elaborate later. And finally, was Aziz Bhasha correct in accepting the antecedent historical data on AMU's Muslim character, but denying it constitutional significance while deciding the issue of minority status? And my lord, this is at variance with various decisions, and therefore it has been argued that in actual fact, the question, my lord, of antecedent data from their side has been argued, my lord, on the negotiations. We have said that, on the other hand, negotiations plus, my lord, the movement that started. In my respectful submission, reference to Macaulay in 1837, my lord, or even the Woods letter is irrelevant. What is relevant, my lord, is the 1904. That is what is relevant. That was a template that was indicated, and Banaras Hindu University and AMU are the exceptions to that template. and that has to be recognized. Then, my lord, I move on, my lord, that it's a question of appeal, my lord, on whether Aziz Basha, we've raised these questions relating to Aziz Basha, my lord, and therefore to say that Aziz Basha is not an issue, my lord, would be entirely incorrect. I won't go more than that, my lord, on this. My lord, the cross-reference of the appeal is CA 2286, questions 10, 13, and 14. This is squarely raised before your lordships, and there is no point taking a narrow interpretation that all that has been decided by your lordships is the unanswered 3A. This is broadly speaking on the reference, my lord. The reference is not singular, but the reference is multiple, and a mere reading of the 2019 reference will illustrate the various points I've indicated there. Now, my lords, I then want to go into the question, and the way I formulated it is minority rights before and after the adoption of the Indian Constitution. The reason why I say before, my lord, the 1909 Act recognizes the minority character of Muslims. In an electoral context, no doubt, but definitely the question of what constitutes a minority before the Constitution is squarely raised, my lord, in the 1909 Act, in the 1919 Act, and in the Government of India Act. Later on, my lord, one other minority is added, that is Sikhs. Therefore, minority status, my lord, is something that was known before the Constitution. It isn't a question that arises only after the Constitution. Certainly, my lord, the courts were aware and the relevant provisions, my lord, of the particular statutes, my lord, I'll indicate later. After the Independence Act, my lord, there are 2 points that have been mentioned by your lordships. The first is the dispensation of Article 30. That's, my lord, an important, and the second is the dispensation of the UGC Act. Now, what prevailed, my lord, after the UGC Act, in essence, is also prevailed, my lord, before the Constitution as well. Had this minority character not been recognized, my lord, there would have been no partition of India. So coming up, my lord, from 1909 all the way to the Constituent Assembly debates, we see that the minority character is fundamental, my lord, to our understanding of what was there before the Constitution. Now, my lord, let me take my lords through that portion of my submission on page 6, my lord, PDF 6. I've indicated, my lord, in para 2.1 that the Indian Councils Act, 8 out of 27 elected members were reserved for Muslims. This is definitely an indication of the concept of minority before the Constitution. Then, my lord, the Government of India Act, I've indicated that in the upper house, out of 34 members in a 60-member house, 10 were to be elected by Muslim separate electorates and 1 member for the Sikhs. Then, my lord, in the lower house, out of 104 were elected in a 145-member house, 30 were Muslim constituencies and 2 were Sikhs. And then, my lord, the Government of India Act, the upper house out of 156 in a house of 260, that's 104 to the rulers of the Indian states, 104 were given, my lord, to the general electorates, 49 for Muslims, 6 for SC, and 4 for Sikhs, 6 for women, and 2 for Christians. Then finally, my lord, in the Federal Assembly, out of 250 seats, out of 375, Muslims got 82 seats, 24, my lord, at that time, and obtained nearly 33% of the seats. The point I'm indicating to your lordships, my lord, when Nehru was asked in July 1946, will you yield the question of political representation? And he said, we'll do nothing of the sort. And that is the term that takes place, which leads to partition. So the issue was fairly and squarely there. After the Constitution, your lordships will just have a look, my lord, at 2.2 on page PDF 7. On the positive side, my lord, 25 to 28 guarantees, including freedom of conscience, right to freely practice, profess a religion, right to establish charitable institutions, and non-interference in religious affairs or imparting religious instructions. Your lordships had mentioned 29.2. The reconciliation between 29.2 and 31 is you can't discriminate to the other people. That's 29.2. But you can discriminate under 30 for your own people. Then, my lord, on the negative side, my lord, I want to mention the importance of two aspects. The non-discrimination aspect is one aspect. And, my lord, the positive part is Article 30 or 25 to 28. So I've indicated that Articles 15.1 and 16.2 are the negative part, dealing with discrimination. You cannot discriminate on grounds of religion. But Article 15.5 and 15.6 is important. I'll just read that portion out. 15.5, my lord, ends with the underlying portion, other than the minority educational institutions referred to in clause 1 of Article 30. So, my lord, this exception is an important exception. Therefore, not only do you get constitutional recognition, you also get statutory recognition. And likewise, my lord, 15.6 on PDF 8, it says, other than minority educational institutions referred to in clause 1 of Article 30. So, my lord, statutory recognition is given as far as Article 30 is concerned, as far as 15.5 and 15.6 are concerned, my lord. And constitutional recognition, of course, is there in Article 30 and 26. Parliament has accepted that minorities have a right to establish and administer a university by virtue of the National Commission of Minorities Act. The definition, my lord, in the National Commission of Minorities Act is inclusive. And then, my lord, after the amendment that was made, it includes universities. 10A, my lord, says a minority educational institution may seek affiliation to any university of its choice, subject to such affiliation being permissible within the act under which the said university is established. When we come, my lord, to the other statutory recognition, Pramati, at 2.4a, we, however, hold that the 2009 Act, insofar as it applies to minority schools, aided or unaided, is covered by Clause 1 of Article 30. Pramati arose in this way. My lord, whether certain aspects applied to the minority or not. And Pramati was absolutely clear, it does apply to the minority as well. Then, my lord, the Central Educational Institution Reservation in Admissions Act 2002, which also provides for reservations in higher educational institutions.
This is an exception for minorities.
And an exception is carved out, my lord, once again for minorities. So I'm looking at present, my lord, in the constitutional dispensation and also, my lord, in the statutory dispensation. That is the voice of Parliament clearly saying that minorities are accepted in 15.5, 15.6 and the various statutes. Now, my lord, the concept of minority goes to the root of minority protection under the Indian Constitution, which has been recognized as a basic feature of the Constitution and its secular framework. Now, secularism, my lord, as understood by your lordship's judgments, one of the important components of secularism is, in fact, minority characters and their protection. Now, my lord, in Pramati, a very interesting point was made by quoting, my lord, the former Chief Justice Sikri. And what he says, my lord, here, after quoting from Justice Sikri's judgment in Keshwanan, I won't read out that particular paragraph, my lord. Thus, the power under Article 21A of the Constitution vesting in the state cannot extend to making any law which will abrogate the right of the minorities to establish and administer schools of their choice. Now, my lord, the suggestion made by Chief Justice Sikri was in fact that you can't even amend the Constitution as far as Article 30 is concerned. Then, my lords, the concept of minority education goes to the root of minority protection, which has been recognized, my lord. I've already said that. Over the page, my lord, we've already read these portions out to your lordships, that minority institutions is consistent with the doctrine of equality. Once again, my lord, Justice Kripal has been cited, and my lord, Justice Khanna. Respondents suggested that an affirmative action of AMU's minority status would be contrary to the public interest, as it would be. I'm sorry, my lord, my learned friend wants me to read the bit, my lord, in TMA Pi. Article 31 ensures protections to the linguistic and religious minorities, thus preserving the secularism of the country. So there is a connection between secularism, and an attempt was made to treat secularism and give it a narrow meaning. Minority protection, my lord, goes to the heart of what secularism is about, and, my lord, consistent with the doctrine of equality. And in St. Xavier's, my lord, the portion, my lord, which we have underlined, special rights for minorities were designed not to create inequality. Their real effect was to bring about equality by ensuring the preservation of minority institutions and by guaranteeing to the minorities autonomy in the matter of administration of those institutions. The differential treatment of minorities by giving them special rights is intended to bring about an equilibrium so that the ideal of equality may not be reduced to a mere abstract idea, but should become a living reality, and the result is true genuine equality, and an equality not merely in theory but also in fact. Therefore, my lord, the point I'm making, my lord, in this segment of my submission is there is a constitutional premium as well as a statutory premium which is attached to minority exceptions and the minority dispensation. It is not just Article 30, but if we go through the statutory dispensation, then it will become quite clear that Parliament has also come in to say we accept the minorities from 15.5 and 15.6. Now, my lords, I come to page 11. My lord, the argument really on their side has been surrender, and on our side has been continuity. It is ultimately, my lord, left to your lordships to finally decide whether there was continuity or whether there was a surrendering. And in our respective submission, my lord, at 3.1, it is undisputed that MAO College and their affiliate bodies are the nucleus of AMU. Now, much has been said, my lord, about the determination of fact which cannot be removed. In actual fact, there is only one and one only, my lord, aspect of fact, my lord, is that the MAO College and their affiliate bodies are the nucleus of AMU. That is the fact that was decided by Aziz Bhasha. And even if we accept their argument that facts cannot be changed in a reference which I believe is incorrect, my lord, there is facts and law, there is facts and there is law. All of them, my lord, come under the dispensation of Bengal immunity. So when you look at all this in Bengal immunity, which is the stare decisis point, when you look at them, certainly the foundational aspects of Aziz Bhasha can be re-examined. And therefore, this subtle distinction about facts not being the subject matter of appeal or reversal is not correct. Now, my lord, here the statement of objects and reasons in the preamble shows that the Muslims intended to convert and incorporate Mayo College and its affiliate societies into Aligarh Muslim University. That, my lord, you will just see the statement of objects and reasons. The Muslim University Association, having requested the foundations of a university and certain funds and property being available to this end, it is proposed to dissolve that association of and Muslim MAO and to transfer the properties to these new bodies. Now, my lord, in the preamble, my lord, it also says a teaching and residential university and to dissolve the Mohammedan Anglo-Oriental College, Aligarh, and the Muslim University Association, and to transfer and vest all their properties. It is for your lordships to decide whether the surrender argument, my lord, is an accurate argument, or is it that it was a continuity? And as far as continuity is concerned, we have mentioned in 3.2b, Lord, 4.1 and section 4.2, assets of the MOO and its affiliate bodies in their entirety were transferred and vested in him. That is an argument of continuity. It's not an argument of surrender. Then, my lord, section 4.3, reference to the MAO college or its affiliate bodies in any enactment prior to 1920 will now be construed as AMU. That is an argument also, my lord, in my respectful submission, of continuity. There is no surrender involved. Obviously, one phase finished and a new one started. But the continuity is very much a part of this process. Then, my lord, 4, section 4, references to AM College or its affiliates bodies in any will, deed, or other document will now be construed as AMU. This is an argument of continuity. Then, my lord, section 7, donations received, including 30 lakhs collected by the Muslim community, is to be kept as a reserve fund. That too, my lord, is an example of continuity. There is no surrender involved, my lord. The Act is absolutely clear that these are provisions of continuity. See on the top of page 12, my lord. All employees become employees of AMU. Now, your lordship is aware in service law, when this transfer takes place, it is not an argument of surrender, my lord. It's an argument of continuity. And most important, the objects of MAO College, promotions of Islamic learning and special provisions for Muslim students have been incorporated in the 1920 Act. Section 5.2, my lord, we have read all these before to your lordship, so I'll just quickly run through them. 5.2 on the promotion of Oriental and Islamic studies and instructions in Muslim theology and religion. 5.12, furtherance of art, science, and other branches of learning, including professional studies in technology, Islamic learning, and Muslim theology. The proviso to section 8 says the power to exempt women, which is very much, my lord, an aspect of continuity. Section 9, compulsory instruction in Muslim religion for Muslim students. And then, my lord, this of course was later on deleted. Establish intermediate colleges and schools within the vicinity of MA College and provide instruction in the Muslim religion and theology. This is precisely what was taking place, my lord, before the 1920 Act. Then, my lord, 27J can make statutes for the instruction of Muslim students in Muslim religion and theology. This too, my lord, is a continuation from the spirit of MAO. Then, my lord, the 1920 Act ensures complete non-interference in matters affecting religion or religious instruction. For instance, the proviso to section 28 provides that the instruction of Muslim students in the Muslim religion and theology did not require submission and approval that was ordinarily applicable under section 28. Then, my lord, students, and this is the most important example, my lord, of continuity. that existing students in the MAO college would become the responsibility of AMU, including provisions of instructions as per the prospectus of Allahabad University. So now this can only be an argument of continuity. It cannot be an argument of surrender. It says those students who were there will come now in the dispensation of the AMU Act. And then, my Lord, Statute 21, the registered graduates was to contain graduates from other universities who had been educated for at least 2 years in MOA college. This is an example, once again, my Lord, of continuity. Now, my Lord, the next is Aziz Pasha squarely accepts that the existing MAO college, this is a quotation, was made the basis of the university and was made over the authorities established by the 1920 Act for the administration of the university, along with the properties and funds attached to the college, the major part of which has been contributed by Muslims. Then it is true that clear from the 1920 Act that the nucleus of the Aligarh University was the MAO College, which was till then a teaching institution under Allahabad University. The conversion of that college, if we may use the expression, into a university was, however, not by the Muslim minority. It took place by virtue of the 1920 Act, which was passed by the central legislature. The fact that it was based, this is another, my Lord, finding a fact that it was based on MAO College would make no difference to the question as to who established Aligarh University. Then 20-2. This is also, my Lord, the error in establishment, which we already argued, so I'm not taking your Lordship through it, that the mechanism, my Lord, was the 1920 Act. '22 Act didn't call for any surrender. It was just a mechanism by which you converted MAO, my Lord. And then, my Lord, the annexure to 1920 gives the name of foundation members. I'm instructed, my Lord, and I've seen that particular list of trustees. All 124 were trustees in MAO. Mr. Dwivedi thought this was not possible, but there were 124 trustees. Then, my Lord, the annexure foundation member, I will not go there. And then, of course, in the 1920 Act, no person other than a Muslim shall be a member of the court, which, of course, was changed, my Lord, in 1951. Then, my Lord, as I indicated to your Lordships, there is a limit to which imperial history, such as Macaulay's Minutes, 1837, Wood's Dispatch, and Hunter Commission report have significance in determining the minority character. It is not necessary to go into Macaulay's understanding that the idea was to reproduce Englishmen, nor was it necessary to refer to the Hunter Commission on recognizing degrees. Now, my Lord, there's a very interesting, my Lord, book on Napoleon. And Peter Gale, who edits that book, says, we can go into history as an argument without end. And this is what has really happened. One side citing what they believe is surrender, and we citing what was the mood at that particular point in time as explained in the various provisions and the background. What is relevant, my Lord, when we look at parliamentary history is not these background factors. What is relevant may be the speech of the minister, the select committee, and parliamentary debates. All the rest of it, my Lord, are not relevant except as an exercise in mood making. And there has been so much of a difference between what we argue, that an entire movement took place, and their argument of surrender. Because what we've argued is there was a movement from the original college and then schools, and then it culminated in the 1920 Act. So, my Lord, the question of surrender did not arise at any point in time. It is a play on words, nothing more than that. surrender always sounds like a stronger word, my lord, than a movement. But there was no surrender at any point in time. And this argument, my lord, is entirely and totally a play on words and nothing more than that. Then, my lord, through a selective reading of the material on AMU's historical antecedents, the respondents have argued that the minority Muslim community surrendered the denominational character of AMU. The 1920 Act read as a whole, along with the statements of objects and reasons in the preamble, clearly reflect on the denominational nature of AMU. The legislative debates are unequivocal to support this view. So, my lord, the education minister, I've given the references, my lord, I don't want to read all of them out. The education minister, when introducing the AMU bill, narrated the entire history of how AMU came into being from the foundation of MAO College to negotiations with the Muslim university for its conversion into a Muslim university. The education member also used the phrase Muslim university and stated that it will be of immense benefit to the Indian Muslims. Then, my lord, I referred to Khan Bahadur's Miss Asad Ali Khan. Though we are first in the field of launching out a scheme for a teaching and residential university on denominational lines, our sister community, which started much later than the Banaras scheme, achieved their objects sooner than us. The Raja of Mahmudabad, this will be the second denominational university in this country. I'm making this point, my lord, because it is really, really very important, because that was a major argument, my lord, canvassed almost right throughout the day, that these are arguments of surrender. You look at it from another point of view, eventually, of course, your lordships will have to decide it. On page 16, sorry, where? Sorry, the Raja of Mahmudabad, then, my lord, PDF 16, my lord. At the time of passing the bill, the education minister stated, "My lords, today your excellencies, government is committed to the custody of the Muslim community, a priceless trust, the incalculable benefits of which will be enjoyed not only by themselves, but also their children and their children's children." And the Governor General says, before putting the question, I'd like to add my congratulations to the Muslim community on the passage of the bill. Now, this being an important point, my lord, eventually your lordships will decide and look at the debates and the so-called items of surrender. I think they're irrelevant until we reach the 1919 bill. They're completely irrelevant, because ultimately it is that bill which was converted into an act read as a whole that will determine whether it is a surrender or whether it is a continuation. I've already made that argument. Now, important question, my lord, which is consistent with their argument of what is the indicia of a minority. And my lord, the Chief Justice said, please delineate those particular. So I'll read it, my lord. For one, the question of indicia of the minority is an issue which squarely arises from the issue number 3A left open in TMA Pi and quoted in the reference order of 2019. We, my lord, have divided the indicia into two parts. The first, my lord, is factors which are relevant to be considered, which are indicative of the minority character, and factors which are not determinative of minority character of an educational institution. The determining factors are founders should belong to either the religious or linguistic minority. The community must be numerically less than 50% of the total population in any state. This is TMA Pi, my lord. This is the numerical test. Historical antecedents to of the institution which show the active involvement, intention, and contributions of minority founders or the community. So That, my lord, is taken straight from St. Stephen's. Their argument that if Stephens were allowed to, were invoked, my lord, to determine the minority character, my lord, then the historical antecedents would clearly show that the contributions was active involvement, intention, and contribution of the month. Now, my lord, para 8, it was argued that there's nothing in the statute. It may not specifically may not mention the fact that Aziz Bhasha was being overruled. But para 8, and I must bring it to your lordship's attention, para 8, my lord, clearly goes against Aziz Bhasha. I'll just read that again. Article 31 has been construed by this court without referring to those cases. It is sufficient to, what is this? To say that the clause contemplates two rights which are separated in point of time. The first right is the initial right to establish institutions of minority choice. Establishment here means the bringing into being of an institution, and it must be by the minority community. The next sentence is important. It matters not if a single philanthropic individual with his own means founds the institution or the community at large contributes to the funds. Now, it is our submission earlier, to which there is no reply, that even if one single philanthropic person were to contribute and other contributions were made, funding, my lord, would not be an issue, whether it's 100% or less than 100%. It is of no consequence whatsoever. The position in law is the same, and the intention in either case must be found to found an institution for the benefit of a minority community by a member of that community. It is equally irrelevant that in addition to the minority community, other than from other minority communities, or even from the majority community, can take advantage of these institutions. This, my lord, gets us into the question that there were several interpretations in Aziz Bhasha of whether it means establish or not. And this now, my lord, effectively indicates that the issue is one of founding, and it can be by one individual, contributions can come from other individuals, and it would not make no difference to the minority character. Then, my lord, over the page. I'll skip 4, my lord. Constitutional documents such as state, statute, rules, or regulations read as a whole should show the predominance of the minority community. That's St. Stephen's. Administration of the institution, if it's vested in the founders or persons in whom the founders have faith and confidence. Now, this is an important point, my lord, because you needn't have found it. The idea here being that it must be of people in you have confidence. And this is important because I may put people in the operative institutions, but as long as I have faith in the founders, and the founders and others, my lord, in this stream of events, my lord, it is their faith and confidence that is important, not 100% this way or that way. Then imparting of religious education or providing of religious institution and worship, this is, my lord, also a point that goes into indicia. And then symbols such as the name, architecture, motto, and other cultural symbols of the minority. Now, in Allahabad, my lord, there was about 2-3 volumes of the architecture, the invocation to God and invocation to Allah. And this is repeated in St. Stephen's because they say these are also indications and part of the indicia of minorities. Now, factors which may not be determinative. Incorporation or establishment by or under a statute. This may not be determinative. Recognition of degrees may not be determinative. Receive of grant and aid, funding from members outside the minority community, quoted with approval at TMA Pi, para 109 and Patro. role of government or its regulators to prevent maladministration. This goes to the heart, my lord, of the role of the oversight of the rector or the visitor, as the case may be. I made a distinction earlier between what are the oversight provisions and what are the administrative provisions in the statute. So even if we say these three declaratory provisions were in fact ruled out, the rest of the statute will certainly show the minority character. Then, my lord, regulation for promoting excellence. Your lordships will see that because it's an important point in only this sense that, and I'll come to the national character, my lord, later. How can it be that when you promote excellence to the highest point, which is of national character, how can it possibly, my lord, in my respectful submission, my lord, how can it possibly take away the minority character? I will make some submissions, my lord, a little later on, as far as the item 63 in the list 1 is concerned. Provision of secular education and admission of non-minorities is not, my lord, as a factor which will be determinative. Provision of secular education and admission of non-minorities, my lord, is not. I'm not going to read out those portions of the judgments, my lord, I've indicated them. My lord, are not going to take away from the minority character. In fact, the entire set of arguments was, we want to be an institution of excellence. So if I reach right over the top and say it's national character, you say this will take away. And that couldn't be right, my lord, because we accept that institutions of excellence will certainly, my lord, be a factor that we will take into account. Then, my lord, recognition as institution of national importance is not a definitive character. Presence of non-minorities in administration and day-to-day management, my lord, doesn't detract in any way from the minority character. Now, my lord, I want to address the question, my lord, of this national character. Let us be clear, my lord, of the 4 points which are not here, my lord, which I want to. My lord, entry 63 relates to competence. Then, my lord, 63, entry 63 is subject to Article 30. Then, my lord, I'll leave that for the moment, because those are the arguments that arise out of entry 63. It relates to competence. These are fields of legislation. And nowhere can we argue. I'm sorry. Was it going very badly? Yes. Say I'm going too fast. So much of it has been argued before, my lord. It's not necessary to.
What is meant by national character? I mean, what was there in the constitution? Why did they introduce these words, national character? Because they seem to suggest that national character is in national importance. Right. They are suggesting national importance to be in contrast to denominational.
Right.
That's their whole argument.
My lord, my learned friend will elaborate on that. My lord, in any case, the opposite of national character, as it were, importance, my lord, national importance. The converse side of this particular argument is that these are then institutions of super excellence.
Yes.
May I just read that portion, Malone? It was. Now just see the institutions known at the commencement of this constitution. Lord, since your lordships were hurrying up the rest, I thought I was under that aspect as well. Hence the speed, for which I apologize. Now let's have a look at 6. The institutions known at the commencement of this constitution as the Banaras Hindu University, Aligarh Muslim University and Delhi University. The university shall be established in pursuance of Articles 371E and any other institution declared by Parliament and by law to be an institution of national importance. So, my lord, it's national importance. Then I have a look at, my lord, 64. That is on the technical side. And once again, the emphasis in entry 64 is once again, my lord, institutions of national importance. Then a variant of this is in Article 65, that is professional education, promotion.
Actually, Dr. Dhawan, if you see, prior to the 42nd Amendment to the Constitution, entry 11 of the state list, the state list, dealt with education, including universities, subject to the provisions of entry 63, 64, 65, and 66 of List 1, and entry 25 of List 3.
Yes.
So, education was a state subject, subject to entry 63 to 66.
Then it became a concurrent subject.
And entry 25 of List 3, prior to the 42nd Amendment, read vocational and technical training of labor. Therefore, what entry 60, say in this case, entry 63 of the Union List did was, once the subject was in entry 63 of the Union List, namely institutions of national importance, these two and any others that Parliament may declare, it was taken out of the fold of the state list. So the exclusive jurisdiction to legislate was conferred upon Parliament.
And therefore, not the
Therefore,
state.
it was really something which related legislative competence. What the 42nd Amendment did was, it deleted entry 11 of the state list. It substituted entry 11 of the concurrent list because that dealt vocational and technical training of labor. And now, post the 42nd Amendment, you see entry 25 of List 3, which says education, including technical education, medical education, and universities, subject to entries 63, 64, 65, 66. Therefore, ordinarily, but for entry 63 of List 1, the entirety of the field of education would have been in the state list prior to the 42nd Amendment, and after the 42nd Amendment in the concurrent list. In respect of these two institutions, Aligarh and Banaras Hindu University, and such other institutions as may be declared to be of institutions of national importance, the legislative competence is exclusively vested in Parliament. So the idea of this was, it appears, that in respect of institutions of national importance, there must be some degree of uniformity of the legislative structure, and therefore exclusive jurisdiction is conferred upon Parliament under Article 245.
And not on the states.
And not on the states. That seems to have been the scheme of the Constitution, pre the 42nd Amendment and post the 42nd. Now, what really we want to ask you, and that's something which we have been reflecting on their argument. They see that once an institution is declared as an institution of national character, then calling it a denominational institution would somehow seem to detract from its institution, from the institutional status of a national importance. Is there any substance there? Obviously, you're arguing to the contrary, but why do you say that there's no antagonism between an institution being of a national importance and yet having a minority character?
After TMA Pi, indicated that the states will be the unit on which you determine the numerical character.
Right.
There is, of course, a different argument by Justice Umapal, where she said it depends on the statute. But once you have accepted that these are the state subjects, which is linked to the idea of numerical importance, then the states will legislate. If it is reached a level of excellence, a national importance, my lord, is an indication of excellence. That is over and above. It applies to Delhi University, it applies to Banaras, it applies to Aligarh and a huge number of other institutions. So, my lord, at the end of the day, this was left in the preserve of list 1. So that's the important point here, that they didn't want to, my lord, as far
So
as
the distribution of the subject, whether it's in list 1, list 2 or list 3, would have no bearing on its minority or non-minority character. Because these are really subjects of legislation and define the distribution of competence between Parliament and the state legislatures on the one hand.
Yes, that's right. And these lists, my lord, are actually on the question of competence.
Absolutely.
Nothing else, my lord. And therefore, if competence vests in the national character or national aspects, my lord, then quite clearly what they are trying to say here is that will be declared. It doesn't go further than say that it is of national character across states.
That's fine. Is this. I'll just show you one or two other entries to buttress this interpretation. Once an institution has been declared by Parliament to be of national importance, what would otherwise have fallen for regulation as a list 3 item is taken out of list 3 and then vested under entry 63 of list 1.
Yes.
Take, for instance, entry 52 of list 1. Industries, the control of which by the union is declared by Parliament by law to be expedient in the public interest. So once there is a declaration by Parliament within the meaning of entry 52 of list 1, it goes out of industries which fall within the control of the state governments. See, for instance, entry 24 of the state list. Industries subject to the provisions of entries 7 and 52 of list 1. Entry 52 of list 1 says those which are declared by Parliament. So once there's a declaration, absent a declaration, it still continues to be a state subject. Once there's a declaration, it ceases to be a state subject and it becomes a central subject. Likewise, in the case of entry 66, these national institutions of national importance, if there's no declaration by Parliament, we are not dealing with for a moment AMU and DHU. If there's no declaration by Parliament within the meaning of entry 63, it's still covered by the state state's power to legislate by entry 25.
A significant point would be, does this trump Article 31 or not? And in all, whether it's the legislation of the state or whether it's legislation of national.
Conceptually, it should not, because all lawmaking in pursuance of the jurisdiction under Article 245 and 246 subject to the entries is subject to the fundamental rights.
It must be the law.
So the fact that something is of national importance may not at a constitutional level be antagonistic to the concept of it's still yielding to minority rights. Whether there are minority rights here is a separate issue. But at a conceptual constitutional level, you can't accept that merely because it is of a national importance, therefore there cannot be minority control over the institution. That wouldn't be the scheme of the Constitution.
That's right, Mama. Because what happens, national importance is there, as I indicated, as a sign of super excellence. So that is there. But there is nothing within the competence that says it will trump Article 31. Nothing. Their argument, my lord,
yes,
is that once you enter into the arena of national importance, then instantly it cannot be a minority institution. That's their argument. There's nothing to suggest that it can't be. Fundamental rights will trump the issue of competence. And this subject to the provisions in the state list, my lord, is writ large over many other entries.
See, for instance, entry 54 of the Union list, regulation of mines and mineral development, to the extent to which such regulation and development under the control of the Union is declared by Parliament by law to be expedient in the public interest.
Correct.
And then entry 23 of the state list, regulation of mines and mineral development subject to the provisions of list 1 with respect to regulation and development under the control of the Union. So once Parliament makes a declaration under a list 1 subject, then that is to that extent denuded from the power of the states under list 2 or the list 3 as well.
Noting the scheme of 245 and 256, that is all on the question of competency. But their argument goes one step further. That is, if it is of national importance, it can't have a minority character. That's the essence of the argument that they have made on public importance, national importance. Article 30, my lord, cannot be read out of existence on an issue of competency. And nothing in these schedules, my lord, of whatever nature, whether it's public interest or whether it's national importance, every single statute in any of the lists will be subject to 30, as indeed Article 19, 21, 26.
Well, I just wanted to mention, Dr. Ambedkar, in the context of institution of national importance, said the following. With regard to subsequent part of the entry relating to any other institutions declared by law by Parliament, it seems to me that it is desirable to retain those words because there might be institutions which are of such importance from a cultural, or a national point of view and whose financial position may not be as sound as the position of any other institution and may require help and assistance of the Sanjay.
Where do we get this? In the
This is Dr. Ambedkar Madam Square, the draft constitution.
We have expected in the submission also. It's there. In my sense, we expected. This is expected in my submission also later.
4B118.
National importance because it symbolizes the ethos of the constitution where.
Therefore, the parliament has been given the power.
That's correct. It can't be, Madam, that merely because it's a minority, it will not be of national importance to give it the status of a institution of national importance. It can't possibly be. Anyway, I'm sorry, Madam, I interrupted. Cultural importance.
The importance of this is when can the minority character under Article 30, when does it become defeasible? Never, my lord. In fact, Chief Justice Sikri goes to the extent that even the amendment power must preserve the nature of a minority.
Let's go to your page 19.
That's the real point, my lord, here. What is it? It's competence, exclusion of competence, and then, my lord, subject to Article 30, subclause 1. It can never, my lord, fundamental rights can neither be waived nor are they defeasible. And that premium, my lord, on fundamental rights cannot be taken away by the issue of competency. That's basically, my lord, the argument. How they distribute the power, my lord, between the center and the state is different. Because even in 62, the institutions known as National Library, Indian Museum, etc., declared by Parliament.
Dr. Dhawan, perhaps, what Basha said was, Basha's logic was that you could not have set up a university whose degrees were recognized. And because you could not have set up a university whose degrees would be recognized, you followed this route. And because you followed this route, necessarily there is a surrender of your, they don't say surrender. Therefore, this is not established by a minority. That's the logic.
Used in Aziz Basha in only one context, property. The word surrender is used in only one place. Just find that.
Yes, only property.
But only property.
The other side has gone beyond Basha, reasoning of Basha.
They say there was a complete surrender.
They have referred to the antecedent facts that repeatedly there was the different point of views, and by choice they accepted certain conditions which indicate that they give up their status as a minority institution,
yes,
even if we apply the dictum in doctrine as exists post the constitution.
Yes, that's right. That's right. But they've elevated national importance to be a denial of 30.
So this is a separate argument.
That's a separate issue altogether.
Fine. Now, my lord, if you look at 62, 63, and 64, once again, it requires the declaration of national importance. And when it comes to, my lord, state list, there are many provisions in the state list that make it subject to the union list. This is a question of division of power, nothing more. Now, may I come back to my...
Yes, page 19.
Which one do I have?
Administration में थोड़ी दिक्कत होती है.
Lord, the factors, I hope I made myself clear on factors that go to the root and factors that are not determinate. Age, my lord, is not determinate. Admissions are not determinate. In fact, St. David's case that is cited there, they had the right to grant degrees, but they said because there is no statement that it is a university, we won't treat it as a university. So the converse proposition arises from St. David's in Aziz Basha. Now, my lords, I also wanted to emphasize, my lord, that the absence of statutory declaration of minority status is not determined. Think through to them in any way. Workshops will come to PDF 19. 4.5.
Yes.
So, my lord, Sir Syed Ahmad, because this is the movement of the community, not just the negotiations. Sir Syed Ahmad, members of the MAO College Committee, trustees of MAO College, and members of the Muslim University Association were all Muslim. The reserve fund of 30 lakhs was substantially donated by members of the Muslim community. The historical antecedents clearly show the predominant role of the Muslim community in founding AMU. The intention of the founders to establish AMU for the benefit of the Muslim community is also unequivocally reflected in historical documents, including the debates to the 1920 Act. The 1920 Act must be read as a whole. And we find that even if, my lord, the minority character, we take away the declaratory provisions, it will still be established from the document as a whole, the Act as a whole, that it is of minority character. Because of the various provisions, which are provisions of continuity and provisions which repose a certain amount of faith in the Muslim community. No. Then, my lord, come to Sub-Roman 5 or 4.5. 3 out of 4 officers of the university, this is in the 1920 Act, Chancellor, Pro-Chancellor, and Vice-Chancellor were required to be Muslim. If we're looking at the 1920 Act, the court being the supreme governing body were required to be Muslims by law. That is, my lord, again, we're looking at the 1920 Act. The 2 other authorities, Executive Council, Academic Council, were predominantly Muslim because the majority of them had a seat in the court. Then, my lord, the others that I've already referred to.
Mr. Dr. Dhawan.
Well, I prefer Mr. Doctor was 50 years ago.
That we have a continuing dialogue since the time when you were arguing Ayodhya before us. But we have to rise today at 3:30. In the highest traditions of the bench, 2 of my colleagues are going out of town for a wedding this evening and coming back at 1 o'clock at night so that the CB hearings are not disturbed. So I thought I'll just give them a little more time to reach the airport. But they said that they will not, allow the CB hearings tomorrow, just as Surya KANT and brothers SATISH, that we'll come back in the night so that we are here on duty tomorrow morning. So we'll rise right now. Tomorrow morning we'll continue. Dr. Dhawan, just one last thing. If you could maybe dwell on the administration aspect, because they have dealt quite substantially that administration was never vested in Muslims because.
In the next part of the note, and Mr. Sibal will deal with it more elaborately.
Fair enough.